Can't hear you.
Next webinar, which is moderated by city staff. Anyone wishing to view the hearing may watch on YouTube. Participants who have registered in advance will be connecting with their computer, tablet, smartphone, or telephone and have the option of participating via video or audio only. All participants will automatically be muted on entry. When your item is called, each participant will be unmuted by the moderator, one person at a time. We ask that you also mute your devices until you are called on to speak. Those participating by video appearance will be temporarily upgraded to panelists when their item is being held. During this time, your camera will be enabled. You will only be visible during your 5-minute allotted speaking time. At all other times, your video will be disabled and you will be reinstated as an attendee. Committee of Adjustment staff will share presentations submitted in accordance with the written submission deadline. Members of the public and applicants are not allowed to use share screen or any other panelist controls during a video appearance. The host will remove you from the panelist role if you fail to respect this instruction. We acknowledge the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis people. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. In accordance with Sections 45 and 53 of the Planning Act, this meeting of the Committee of Adjustment of the City of Toronto is called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning that applies to property, for permission to extend or alter lawful non-conforming uses, and for consent to sever property to create new lots. Receiving a copy of a decision of the committee. Anyone in attendance today who wants to receive a copy of the committee's decision on an application must submit a written request for a decision by email. Please ensure you include your name, address, and email address because the Committee of Adjustment and the Toronto Local Appeal Body will be sending notifications and appeal updates by email. If you do not agree with our decision, you may be able to appeal the decision to the Toronto Local Appeal Body or in some limited circumstances to the Ontario Land Tribunal. However, the provincial government recently amended the Planning Act and generally removed rights of third parties to appeal Committee of Adjustment decisions. As of November 28, 2022, only the applicant, the Minister of Municipal Affairs and Housing, specified persons and public bodies, as those terms are defined in the Planning Act, are permitted to appeal decisions of the committee. Appeal instructions are set out at the bottom of the decision of the committee. Hearing procedure. I will call each item in the order listed on the agenda. When making your submissions, where an application is uncontested, the agent or applicant may proceed with their presentation if desired. When the committee does not require a presentation, applicants are to advise the chair should they wish to speak to the committee. The committee may ask questions and/or take the matter into committee for a decision. Each speaker, including the applicant agent, will be given a maximum of 5 minutes to address the committee. I will comment when you're reaching the 5 minutes. When addressing the committee, clearly state your name and address. Remember to confine your remarks to the matters outlined in the application. The applicant or agent will proceed first, will make a presentation to the committee on the application. Please note the committee may not entertain revisions to the proposals at the hearing today. The committee may decide to defer the application if substantially revised to ensure the revised application is accurate and that all those entitled to notice of the application are informed of the changes. Then, individuals either in support or opposed to the application will be invited to speak. Committee members may ask questions of each speaker after they have finished their presentation. When all speakers are finished, the applicant agent has an opportunity to rebut only those issues raised by the speakers. This will mark the end of the discussion, and the application will then be taken into committee. Are there any declarations of interest of panel or staff for the items in the afternoon time slots? Okay. Any deferral requests for the afternoon?
Good afternoon, Mr. Chair and panel members. Yes, there are two applications for deferral this afternoon, which are item number 32 for 8 GRASSI Street, which would be an automatic deferral for improper notice, given a revised zoning review was submitted, which identified an increased requirement for the number of visitor parking spaces under a different zoning bylaw and a different section. New notice would be required to identify this change. And then we have item number 33, 534 Perth Avenue, deferral request from the applicant.
You. Okay. First item, 14 Grand Park Court. Purpose of the application to construct a new ancillary structure, ground floor deck at the rear of the existing two-story detached dwelling. This application, material submitted by the applicant, and correspondence in opposition from one address on Grand Park Court. Radzik Goran.
Yes.
Have your name and address, sir?
Goran Karadzic, 14 Grand Park Court. I'm the owner of this house.
Yes. All right, so we need you to tell us what this is about because you have some opposition.
Very well. First, good afternoon, Mr. Chairman and members of the committee.
Would you please, Mr. Goran, please speak into the microphone?
Yeah, we'll come closer. Can you hear me right now? Is it better?
Well, it would be better if you spoke a little louder.
Okay, I'll try.
Thank you.
So, I'm seeking approval for minor variance related to the position of the rear deck in regards to encroachment into the rear yard setback and position to the side lot line. And pretty much this is straightforward. You have all documentation and you have my cover letter. So if you don't mind, I will save my time to address the opposition. My understanding is that I have only 5 minutes.
Okay, panel, do you have any
Additional
questions?
information for me?
Okay. Mr. Laslovic, Ms. Nardi?
Kara and Vlad, you've been unmuted.
Are they there, John?
Mr. Chairman, while we wait for the connection, could I ask the applicant a question?
Yes.
With regard to the expanded proposed deck or the deck, it's existing, it's not proposed. Is that correct?
The deck replacement will not need a permit. So, yeah, it's now kind of catch up, but all the works are stopped and we are waiting for this approval.
Okay, but the deck's there, right?
Oh, yeah.
Okay, and is there along the south property line between you and number 11, is there any kind of a screen or a fence there at present?
Actually, that's probably the solution for this. If you just scroll a little bit down, whoever is controlling the presentation, go down, go down, go down. Next one, next one, next one. Here, you can see, oh no, up. You see the privacy fence is the, in the plan, it's not built. We're waiting for this approval. And actually, you know, I also
Excuse me, that just shows pickets. That's a railing. That's not a privacy fence.
No.
Further down?
A little bit down, you don't see it. Stop.
Okay,
You
so
see-
that portion isn't built, but the deck is, right?
Yes,
Okay, thanks very much.
thank you.
Okay. Mr. Lasovic?
Walter Lasovic and Katerina Nardi, you've been unmuted.
Yes, I'm here.
All right, can we have your name and address for the record, please?
What did you do? Sorry. Sorry, would you say that again?
Hi, sorry, I couldn't
Name.
quite hear you. Can you repeat that, please?
We have your name and address for the record.
Okay, it's Walter Laslovic, 11 Grand Park Court in Toronto, M6S4Z4.
All right, thank you. Okay, can we have your comments?
Okay. Good afternoon, Mr. Chair and members of the committee. The intention of this meeting is to make my views known and oppose the requested variance to the zoning bylaw, Chapter 10.5.40.60, -1-C, bylaw 569/2013. Zoning bylaw states the following: a platform without walls attached to or less than 0.3 meters from a building with a floor no higher than the first floor of the building above established grade may encroach into the required 2.5 meters if it is no closer to a side lot line than 1.06 meters. Okay, I would like to start by saying it is obvious that Mr. Karadzic, the applicant, has constructed elevated wood deck without regard for both construction zoning restrictions and city bylaws that require a building permit for this type of construction. Mr. Karadzic is asking for a variance which he believes to be minor in nature, which is in total contradiction of the zoning bylaw. The zoning bylaw calls for a minimum distance of 1.06 meters away from the property line based on the height of the deck, and the deck is only 0.17 meters away from the south side lot property line. Excuse me, the distance is still in the violation of the zoning bylaw by a total of 0.89 meters, which works out to be 84%, which is quite significant. Mr. Karadzic could have easily stayed away from the property line by 1.06 meters simply by redesigning his deck, as there's plenty of room on the opposite side of his property to work with and easily meet the zoning bylaw. Instead, he chose to build a deck that he wanted to his own liking and design, again, without regard to the zoning bylaws, without applying for a permit first, and without ever thinking what impact the structure may have on the surroundings. Well, it did have an impact on our family in several ways, the main one being the violation of our privacy within our house. We have a large window located in the kitchen on the north side of the wall, 0.6 meters away from the back wall. And from my letter of objection dated March 15th, file size 2.12 megabytes on page 7, you can see the first photograph of that. Under site plan, the height from the ground level of the platform of the deck is shown as being 1.07 meters, and the height of the railing is 1.03 meters. On the same site plan design page, they show a proposal to install a privacy fence of 1.83 meters in height on top of the regular fence. This would create a total height of approximately 4 meters from the ground level. This is not a viable option because the deck is constructed too close to the property line, secured only to the fence, thus risking the possibility of this privacy fence screen not being secured safely, blowing over in high winds and falling onto our side of the property. The privacy fence of that height would unnecessarily create a loss of open space. It would block the sunlight to our kitchen and even to our own deck. The bylaw is clear for this side yard setback to be 1.06 meters and must be maintained. The required side yard setback is in place to enable the property owners to access the side yard between the two houses for any service maintenance. Furthermore, having a deck and a fence to be in one construction will greatly impede the attractiveness of our property when we elect to sell, creating unnecessary burden, since this is a very undesirable feature that many prospective buyers will stay away from. Whenever our blinds are open, they can clearly see into our kitchen as well as into our dining room through our window due to the wide open concept on the main floor. From the same letter of objection, page 9 clearly shows that. Also, the view outside through that window, seeing a bright sunshine, beautiful trees, letting fresh air in, as we were always able to do before the new deck was built, right against the fence. From the same letter of objection, that can be seen on page 11. There's a photograph taken right from inside our kitchen. So the variance of 0.89 meters or 84%, which Mr. Karadzik believes to be minor, is not minor at all, and in fact, it is quite significant, and this encroachment is a major violation of a personal space and privacy, and the best solution would be to reconstruct the deck and move it back by 1.06 meters in order to comply with the zoning bylaw. This can be from the letter of addendum dated March 20th, file size 0.56 meters. I have a drawing of this setup, which appears on page 4. So if you can pull that up, I will describe it. So all Mr. Karadzik would have to do would be to shift the deck away from the fence in northerly direction by approximately 0.9 meters. By making this shift to meet the city's zoning bylaw, he would still have a deck in size of approximately 6 square meters. With this resolution, by moving the deck away from the fence and installing a proper 2-post support, supporting the deck with a railing on that side will be much stronger and safer. So, Mr. Chair and members of the committee, I'm very kindly asking you to please consider all the information and the reasons given with supporting documents, with all the photographs and drawings, and the hardship and the burden that my family and I are going through. I trust that you will come back in support of our opposition to the variance requested. Thank you very kindly for your attention in this matter.
Thank you. Mr. Gorin?
Yes, thank you. Here is my neighbor comment is that this is against the zoning bylaw, and actually this is the purpose of this session, to ask for that to be amended and approved. He was also talking about privacy, and this is actually in all of the comments he made. I strongly agree with my neighbor, because it goes both sides. Our privacy is also affected, and as you can see, he took a picture of me on my deck, which is kind of privacy violation. And exactly as I spoke with Mr. Neifel, his question, yeah, the privacy screen is a solution for both sides to have the privacy. He's also mentioned the window and the view and the sun and everything. That window is actually facing the wall of my house, not the deck, the wall. And my house is on the north side, so there is no sun. He didn't mention that actually on the rear side of his house, he also has an exit to his deck with a huge sliding door. So enough sun, enough breeze and air and whatever he needs. So the side window issue is actually completely not, as I said, this is facing the wall of my house. And I believe if there is any other questions, I can also give the answer.
Okay, any questions, panel? Nimrod?
Yeah, to the applicant, what is the difficulty in you complying with the setback requirement?
You know, let's put it this way. All those listed issues, we are not caused by a new deck. They existed from a day one when the houses were built. And we will remain, and it will, all those issues will remain regardless of the size or position of the deck. Mainly, again, privacy as the biggest issue and all other issues. If I move the deck, again, we can see each other, I can look through his window. I could do that from the old deck as well. On the other hand, also, if we move, then what we are going to get is if I have to move, I will move to the allowed distance, which is additional 0.9 meters, not what Mr. Laslovich suggested on the other side completely. And with 0.9 meters, again, nothing is, so it will satisfy the bylaws, but all we will get is a strip of the deck of 0.9 meters, which is adjacent to the fence, and this space would not completely be unusable and doesn't make sense. And also, the post on a fence was used as a structure for the deck, and that actually that's the main reason why decks was extended.
Yes, Sahir. You're muted, Sahir. Sahir, you're muted.
Sorry about that. I wonder if our colleagues could just pull up the photograph that the person in opposition had shown us. I think it's the last photograph, window looking out to the deck. I think it might be the next one down, that one, yeah. So to the agent from this view, does the deck actually attach to the fence between the two parties? Mr. Karadic?
Unmute myself. Oh, okay. I can't unmute myself. Yeah, deck is attached to the fence, which is completely on my side of the property line.
The fence isn't on the property line between the two parties?
No, it's inside the property line on my property. And actually, that's the root cause of the misunderstanding between us.
And if you propose to put a privacy screen, how much taller would that lattice work be?
Again, it's shown on a but it will be 1.8 meters above the railing. The railing and
you mean 1.8 meters from the deck?
It will be 1.8 meters from the railing of the deck. Yes, not from the fence, but from the railing of the deck. Which
would be just on the top of the fence?
Yeah,
I'm trying to get an idea of when I look out this window, what size of privacy fence will I see?
Maybe if somebody switched to the design to a picture, will explain much better. Oh yeah, go slow down, go down. Just scroll a little bit. No, just no. Go up, up, up. here and just scroll down or zoom out so everybody can see the position and dimensions. Oh, yeah.
So is the lattice work currently sitting on the railing?
Pretty much, yes.
So if one can picture, then at the bottom of the lattice work right now, from there it would be 1.8 meters higher. Am I correct?
Yes.
So just under 2 meters from the top of your fence.
Yes.
Okay, so that's a substantial amount of light being blocked out.
Okay. I believe that this is actually height which is allowed.
Okay.
Thank you.
All right.
Very well.
Mr. Gorin, I take it because there's no variance requested for the fence, that the fence is within the bylaw.
Yes.
So the only objection is that you attach the platform to take advantage of the structure of the fence, and because the fence is closer than the platform should be, you now have to ask for a variance.
Correct.
So what would happen if you didn't attach your platform to the fence? How would you, you'd have to rebuild you'd have to build a new superstructure to hold that platform?
Exactly. New posts, again, 9 meters away from a fence. Then there will be that gap.
So I understand that this platform was built when you were out of the country?
Yes.
All right, and did you discuss with your contractor
Yes.
how you wanted it built?
Yes.
And did he suggest that the bylaw required the platform to be a little further away from the property line than the fence?
No, he didn't.
All right, thank you.
And my last comment is about the height of the fence. All of these drawings and everything was reviewed by examiner in the city, and which you had that. And she also saw the privacy fence, and she didn't have any objections on that. So the only objection was the structure of the fence, which was resolved, and the second objection, actually, she brought that up as an issue, is this bylaw. This is based on that, and this is why I answered that the fence height is correct, because examiner didn't.
So you didn't have a building permit to build the fence or the platform, is that correct?
Correct. I wasn't aware of that the old deck with the new deck, I need.
So the actual privacy screen will be attached to the fence?
Yes.
All right, so it would have been, even if you didn't have a platform, you just had a fence, you would raise up the fence by putting in a privacy screen?
Yes.
All right, thank you, sir. Any further questions, panel?
Thank you.
Any comments? Do we have a motion? Yes, Carl.
Mr. Chairman, it seems to me, Mr. Chairman, that the purpose of the application needs to be amended because he's not going to construct the deck. It's already constructed. So I don't know what wording is appropriate, is to approve, permit, or whatever, but it's already there. And as one of my colleagues mentioned, I think it might have been Nimrod, there doesn't appear to be any restriction, or didn't appear before he started to do any work, any restriction to placing the deck further to the north and away from number 11, which would have been the best solution of all. Having said that, I think that the variance for the side yard setback, or the variance for the location of the deck, exacerbates the situation and makes it worse than it needs to be. All of the points that were explored by Zahir and yourself about the heights are true, but those heights would be further away from the property line if the variance wasn't approved. Having said that, I'm not in favor of the variance, and I'll be voting against it.
Further comments or questions here?
Thank you, Chair. I can, in similar vein to Carl, I'm not comfortable with this particular application as it is. It's not to construct, it's to legalize something that was produced without compliance, and we're now trying to seek compliance and a variance. And I do think that even though the agent has suggested a taller privacy fence, it will now become something that would be even more of an obstruction to the sightlines of the neighbor. And I think the neighbors have a valid concern. So I don't believe I'll be supporting this application either.
Further comments? Okay, do we have a motion? Carl?
Thank you, Mr. Chairman. I don't believe that this is a valid approach to the development of the deck. I think it imposes hardships unnecessarily and on the property owner at number 11, and I move to refuse the variance application.
Have a seconder, Zahir. All in favor? All opposed? Okay, the application is refused 3-2. Number 22. 25 PLAYTER Boulevard. Purpose of the application is to alter the existing 2.5-story detached dwelling by constructing a rear 1-story addition, a rear 2nd-story addition, and a 3rd-story addition. With this application, we have material submitted by the applicant. We have correspondence, or we have reports from Urban Forestry and Community City Planning, and we have opposition from 33 PLAYTER. Tay Ryak.
Yes, sir. It's Tay Rook, planner for the owners of the property at 25 PLAYTER Boulevard.
Okay, could you, there is someone of interest that wants to speak, so perhaps you could give us a brief presentation.
Sure. Before you today is currently existing is a 2.5-story detached dwelling with alterations proposed for the rear 1st, 2nd, and 3rd stories. There are 3 variances before the committee. One being the main wall height at 10.15 meters, FSI at 0.87, and a side yard setback, the north side yard setback at 0.44. What's before you on the screen is an area context map. The subject site is highlighted or outlined in red. You see properties that are highlighted in green, and those are those properties that are in excess of 0.8 in terms of FSI. You find that within the immediate block and also within a broader context. What the committee is probably well aware is that this is a very tightly knit neighborhood in the sense that the houses are very close together. There are existing homes that are actually greater than the bylaw permissions in terms of FSI. The subject site itself has a current existing FSI of 0.74, but you'll also note that the highlighted properties in green represent those existing properties that are above the 0.8 mark. What you also find on that map are those properties that have been dotted with triangles, blue triangles. Those represent heights or main wall heights that are greater than 10 meters in height. As well, and you find that throughout the neighborhood within the immediate context across the street, a couple of properties away from us on the same side of the property as well, in addition to the surrounding blocks as well. Furthermore, when you look at the side yard setbacks from the area context map, and if you look at the side yard on the site plan on the next slide, I've outlined the existing house on the subject site in comparison. So the proposal is maintaining the existing north side yard setback on the north side, which is at the bottom of the screen, and that's at currently existing at 0.44. What you also find is that there is if you go to the next slide, there is a main wall height of 10.15 meters, and on the third slide, you'll see that I've indicated the extent of where that variance is being created. It's the 7.54 meter range from the front into the rear, which is left to the back, left to the right. And that's primarily contained within the middle of the property itself. And the portion, those triangular pieces that have been highlighted in green are actual dormers, and they're not located at the side walls. They're actually centered at the middle of the house, and that's clearly shown on the next two slides, on slides number 4 and 5. So they don't necessarily represent, in terms of massing, that would be felt by the adjacent neighbors to the north or to the south. Furthermore, if you go to the last slide, you'll see that there's a side elevation which shows a blue area, and that blue area represents the existing dwelling that's on the property itself. So from a massing perspective that's being proposed versus what's existing on the property, it's very similar in terms of the massing that's being proposed on this site. You'll also note that there is an existing third story deck on this property. If you go to the existing site plan, existing plans that was submitted as part of the plan submissions, and I know that planning had recommended privacy screens to be placed on the north and south side of the third story deck. We have no issues with that, but I would ask the only issue that may arise from that is that it may create a sense of additional massing towards the adjacent properties, because it would be a minimum 1.5 meter privacy screen for that deck. However, I'll leave it in committee's hand to determine whether or not if it's necessary, and we'll be more than happy to comply with that regard. But you'll see on the site plan, on the north and south sides, the adjacent properties. So on the north side, which is at the bottom of the site plan, or on the left of the current site plan, you'll see that the existing house at 27 Plater, pardon me, is separated by the property line and then a driveway on the north side, which is the left. And then similar, there's an asphalt driveway on the south side, which separates these two properties to 23 and 25 as well. So there is, in addition to the setback, there's a buffer of the driveways on either side, which further mitigates any impacts that may be associated with the height variance. But once again, the height variance is maintained within the middle of the house, midpoint of the house, for a stretch of 7.5 meters. It does not extend from the front main wall to the rear main wall. You'll note that there's a step down effect that's happening along the side elevations. And once again, the massing of the two properties from the existing dwelling compared to the proposed dwelling is very similar in terms of massing. There's also the standard condition number 2 of urban forestry, which we have no issues with. I don't know if there's another person to speak, but I'll be glad to answer committee's questions if they have any.
Yes, Carl?
Thank you, Mr. Chairman. Have you had any discussions with the adjacent neighbors, particularly relative to putting the screening on that's that's proposed by planning? Because I think you raise a very interesting point. You've gone to some pains to have the massing respect the adjacent owners, and the screening could in fact impact the massing. And I'm just wondering if, given their druthers, whether the owners on either side would prefer or not prefer to have that screening, and have you had that discussion?
Well, sir, that planning recommendation actually came in late. It came in on Monday. But we did have, just to let you know, we did have conversations with either neighbors, though their concerns are primarily construction related. You'll also note that, so we didn't have the opportunity to speak about the privacy screen that was recommended by planning staff. However, you'll note that the existing house has a third-story deck, and there is no screening. And that third-story deck at the rear is actually larger than what's being proposed for this particular proposal. So the current, I guess, circumstance or current context is one in which where no privacy screens exist. And you'll also find within the area elevated decks or patios that don't have privacy screen. And it's just the nature of the tightly knit nature of this property or of this neighborhood.
Thank you.
Okay. Mark Kudis.
The setback of the deck at the back, the
Mr.
proposed deck, and no privacy screen.
All right, Mr. Kudis. Mr. Kudis, could you, we didn't catch the first part of your comments, so we'd like to have your name and your address for the record, and then we can have your comments.
Sure. Mark Caudice, 27 PLAYTER Boulevard, Toronto.
And your comments, sir?
My main concern is the setback of the proposed deck at the back and no privacy screen there. We have a privacy fence between the two houses, but in the past there was no deck, so there was no problem. Looking at the proposed deck, I'm just concerned that without a decent privacy fence that we'll just be looking at each other.
Okay, thank you very much. Mr. Ruck, I don't believe we need to come back to you because I believe we've already discussed the privacy screen. So panel, do you have any further questions? Yes, Carl.
Mr. Chairman, with this camera and I put my hand up, I never know if it's on screen. I think that the last speaker, if I'm not mistaken, he's speaking about the proposed deck at grade, not the proposed balcony further up, which is what the planning department recommendation is about. Could I clarify that I've got that right? That the gentleman from, I think he's from
27.
Okay.
Mr.
Is
Kudis.
he referring to putting privacy screen on the north and the south edges of the ground floor deck?
That's correct. It's the ground floor deck that I'm concerned about.
Okay. And you're not the balcony on the third level.
Correct.
Okay, thanks.
And Mr. Kudis, there's no fence between the properties?
There is a fence, but the proposed deck is not at grade.
Oh, okay, thank you. All right, panel, any further questions, comments, or a motion? Yes, Nimrod?
Well, can we just have the applicant back to kind of address that question about the deck at the rear at ground level?
Sure, through you, Mr. Chair. You'll note that there is no variance related to the ground floor deck itself. However, I do not believe my client would have an issue with putting some sort of a privacy screen with that, and that's for future discussions with my client and the neighbor. But from what I understand, that they've been very neighborly and very open with in terms of how this construction is going to take place. So those are conversations that could be pretty much had throughout this process. But we're very open to that. But once again, I'll note that there is no variance related to that deck.
Yes, but if we make it a condition, there's no longer, I mean, you can discuss with your neighbor the material and the height, well, not the height, because we'll probably say it's 1.5 meters, but once we make it a condition, your client will be stuck with that.
We have no problems with that, sir.
Thank you.
But I was just trying to make sure that there's, not to confuse issues, that the deck is related to there's no variance related to any decks whatsoever for this proposal.
We understand that.
Yep.
And just to clarify, what is the height? How high off the ground is that rear ground floor deck?
It's pardon me, I'm just zooming in, 0.5 of a meter, 0.58 of a meter.
And so somebody standing on that deck, and if there's a fence on the side, like how much higher would they be looking
Well,
above that
the
fence?
the deck is about, as you can see there, about almost 2 feet. So 1 feet, 11 inches to the top of the deck. So a standard fence between the properties would be 6 feet. So a person that is above 5 feet would be able to technically look over that fence. So whatever the privacy screen would be at 1.5 meters or 1.8 meters, it would end up being about 6 feet, 6 to 7 feet, 6 feet on top of the deck, approximately just under 6 feet on top of the deck. So in total, it'll probably be 6 to 7 feet in terms of massing.
All right, thank you.
Okay. Comments? Do we? Yes, Carl.
Are we in committee yet, Mr. Chairman?
Yes, we are.
I don't have a lot of trouble with this application. These are very large buildings on relatively small pieces of property, and I think the way in which this proposal has been designed is commendable. I think that the issue of screening from the ground floor deck, because as indicated by the neighbor, it's elevated above ground, does make sense. So I think that a privacy screen on the north and the south edges of the ground floor deck makes sense, and I would include that as a condition. I don't feel as strongly about the balcony as the applicant indicated, and I'm sorry to be bouncing back and forth on this, but the existing balcony, which is shown on drawing, doesn't have a number, on the existing third floor plan is bigger and more exposed than the proposed one, which is on the proposed third floor plan. I don't, Frank, and since there's been discussions and it hasn't been raised, and because of the impact of placing that extra height on that, I'm not as convinced that we need to put a screening on that balcony. So my motion would be approval of the application, subject to forestry condition number 2, and the provision of opaque screening, standard screening on the north and the south edges of the ground floor deck.
Seconder for the motion. Here. All in favor? Have your approval, sir. Thank you. For 23-209 Montrose. Avenue. Purpose of the application to construct a new one-story ancillary building, a two-car garage in the rear yard of the property abutting the laneway. With this application, we have material submitted by the applicant and a report from community planning. Maxine Shabsov.
For you, Mr. Chair, Julia Bork will be speaking instead of Maxine for this one.
Thank you.
Julia,
Hello.
you've been unmuted.
Hello.
Hello, can we have your name and your address for the record, please?
Certainly. Julia Burke, 40 Fernwood Crescent.
Thank you. I don't think we need a
Marked out.
presentation. I'm going to take it into committee.
Okay.
Do you have anything you want to say to the panel before we go into committee?
No, I think it's pretty straightforward. You would note that our first variance for landscape has been omitted. We have removed that from this application as planning has had a concern with that. So we removed that variance, but the others stand, and they're minor to do with the building of this garage.
Okay, thank you. Panel, any questions? Comments, or do we have a motion? Yes, Nimrod.
I think the variances before us are minor now that variance 1 has been removed, and I would move approval of the amended application subject to community planning conditions.
Carl, you
And,
second
yeah.
that? All in favor? Have your approval. Thank you.
Thank you very much.
Number 24, 34 Raymond Avenue. And the purpose of this application is to alter the existing two-story detached dwelling by constructing a rear two-story addition. With this application, we have material submitted by the applicant. We have correspondence in opposition from 31, 32, 29, 76 Raymond Avenue. Don Wade.
Hello, you hear me okay?
Yes. Yes, we can hear you.
Yes, I'm Don Wade of 34 Raymond Avenue.
Okay. Yeah, there's opposition, so I think you better tell us just what this is about. It doesn't look, the variance is only one, and it's not very complicated, but somebody's opposing it, so we need some comment from you.
Well, I'm just looking to create some extra living space in my home. I have family living with me and coming to live with me, my mother-in-law, 89-year-old mother, and my family, my wife and son and myself. So we need extra bathroom and bedroom on the house and some extra living space. So that's all what it's about.
Okay. Questions, Pat? Okay. Martin Taylor?
Martin, you've been unmuted, and if you'd like to use your camera, you can do so.
Can you hear me, Mr. Chairman?
Yes, we certainly can.
Okay, my name is Martin Taylor. I am the owner and resident at 32 Raymond Avenue, adjacent on the east side to the proposed extension. I'd like to reference the letter of objection I submitted on February the 24th, 2023. And this exactly, that photograph is what will help explain my objections. We have lived at 32 Raymond since 2004 and have enjoyed the use of our deck and back garden throughout the warmer months. The proposed 20-foot long, excuse me, two-story extension would completely cover our deck and block off all afternoon sunlight to our deck and back sunroom. On the photograph, you can show the red line on the right, shows where the extension would come to. The red line on the left is a compromise that I would propose that is 10 feet of an extension, as we would no longer be able to have that view. Instead of looking at the neighborhood trees and the sunset on a better day, we would look at a massive brick wall. In summer, we have many plants, herbs and tomatoes in pots on the deck. The extension would prevent them having adequate sunlight and heat, so no tomatoes. We have four trees, 2 large shrubs adjacent to our fence immediately behind our deck. Any excavations for foundations to 20 feet would seriously impact their root zones. The cement blocks and concrete in the foundations would seriously affect the soil pH of the acid-loving plants that we have there. The excavation would also, the excavation machinery would also compact the tree root zone. The loss of afternoon sunlight would also affect a significant portion of the back garden especially where we have focused on pollinator plants. We've spent nearly 20 years developing our garden with plants located according to their sunlight needs. If the application were approved, we would have to consider cutting down 2 of our trees to let in some sunlight onto the back of the garden. We would suggest that the impact of the proposed extension next door renders the variance as not minor. We would recommend a smaller extension, say of 10 feet, which would have far less impact. This would be completely acceptable to us and would allow us to enjoy our deck and garden in our retirement. I should point out that there has been no substantive discussion with the applicant regarding their plans and with the impact that it would have on us. There's also the concerns that if they are digging a large basement next to our house, there is not very much clearance. We would be seriously concerned about the impact of those excavations on our foundations. That's all I have to comment, Mr. Chairman. If the committee has any questions, I'd be happy to answer them.
Thank you. Any questions, Pat? Mr. Wade?
Nope.
Yes.
Aye. I don't believe that the new structure blocks the sun at all. If you look at the site plan, you can clearly see where the sun in the summertime runs from the east. As the sun sets further north in the summertime, the sun clearly runs clear of the addition of what we're proposing and would not affect any sunlight, very little, to his deck at all. And he has a very deep backyard to adjust where he sits if he so desires, as all those backyards are very deep. Everything we've applied for is done by bylaw, done by the experienced people at the permit guys. We're not doing anything out of the ordinary that many, many homes in the area are not doing and have been approved by the city for this similar type of work. That's all I have to say.
Thank you. Rod?
I also, sorry, one more thing. I also have a letter of support from my neighbor on the other side who I share the driveway with, who I feel would be more impacted by the construction process along the way, and he's in full support of it.
Thank you, sir. Imrod?
So if you can just clarify, what is the side yard setback that's you are proposing? I noticed you do not have a variance for that.
The setback, I believe, is done by the bylaw. It shows from the property line, it shows 3'9" on my site plan.
Thank you.
Carl?
Thank you, Mr. Chairman. The gentleman that was speaking about his garden, he's the property to the east, is he not?
Yes.
The property on the top of this drawing?
Yes.
Because I from the photographs that were shown, it didn't look, the proposed addition doesn't appear to extend as far into the photograph as, something doesn't look quite right with regard to the dimensions, but okay, I just want to make sure I got the right property. Thank you very much.
Yes.
May I address that? Sorry.
No, I'm sorry, sir, but we're now in committee. Yim?
I also have the same problem as Kyle. I cannot understand the photograph relating also to the real extension. It seems that from the photograph, the addition will fill up the whole entire backyard. I can't quite get it. There's something not right. I just want to clarify. Yeah.
Here.
Thank you, Chair. Before us, we have one variance, and I'm quite happy with that variance. I don't think it's a major issue. In terms of addressing the concerns of the neighbor, I noticed that in the site plan, the new proposed structure is also set back from the existing structure in terms of the side yard setback. Like my colleagues, I think the visual image that we have in the photograph is perhaps misleading because you don't get a sense of the depth of the two properties, and they are both very deep. So I have no problems or concerns about supporting this particular application. I'd be quite happy to move a motion to approve.
Okay, can we have your motions here?
Yes, Chair. There are no conditions attached to this. I propose, I move to approve this application.
There's a condition. Yeah. Okay. All right, no conditions. Do we have a seconder? Jim, all in favor? Have your approval, sir. Thank you. Number 25. 26 Lakeshore Boulevard. Purpose of the application is to academic and off-base use subject lot. With this application, we have material submitted by the applicant and correspondence from Conservation Authority. Mr. Park.
Good afternoon, Mr. Chairman, members of the committee. My name is Jason Park. I'm with the law firm Kagan, Shastri, DeMello, Weiner, Park, LLP. Our firm address is 250 Yonge Street, Suite 2302, Toronto, Ontario.
Thank you. Okay, I don't think we don't need a presentation. Do you have anything you want to say to the panel before we go into committee?
No, Mr. Chairman, I think it's fairly straightforward. This is a minor variance to expand the permitted uses for the non-residential portion of the development, which has been constructed, which is 315 square meters, which meets the minimum requirements set out in the site-specific zoning bylaw. I have looked at seeing the TRCA comments and I guess the Metrolinx comments, and I understand there are no conditions that are being proposed.
Panel, do you have questions, comments? Motion, Yim?
I don't have any comment. The only thing I think is this is a large development. I think they're going through a lot of a long approval process. I have no problem of granting this approval, and there's no conditions either. Thank you.
Seconder for that motion, Zahir. All in favor? Have your approval, sir. Thank you.
Thank you.
Number 26. #21 Roberts Avenue. Purpose of the application to alter the existing story detached secondary suite with a would also to canopy.
Mr. Chairman, I can't hear you. I'm sorry.
The purpose of the application is to alter the existing two-story detached dwelling by installing a secondary suite within the basement with a rear basement walkout, also to maintain the rear canopy, the vertical chairlift, and the access ramp leading to the existing detached garage. With this application, we have material submitted by the applicant in opposition from 23 McRoberts Avenue. Jason Rodriguez.
Yes, sir. Good afternoon, Mr. Chairman.
Yes. Can we have your name and address, please?
My name is Jason Rodriguez from InterArc Inc. We are located at 1351 Dundas Street West in Toronto.
Okay. You have some opposition, so we need a brief presentation.
Okay. Good afternoon, Chair and members of the committee and staff. On behalf of the property owner, I am here to present the minor variances requested that are before the committee today with respect to the subject property. The application before the committee is to legalize the as-built construction of the existing rear yard canopy and rear yard hard surface area, namely variances 1 and 2. Additionally, a proposed door opening in the existing south wall of the building is being requested to provide secondary access to the basement area and new secondary suite, which is variance number 1. Variances 1 and 2 are for reduced side yard setbacks. Variance 1, as mentioned, is in the existing south wall, and the reason for the variance is the creation of the opening. Currently, that wall has no openings in it, and when walls are added with openings, there's an increased side yard setback from 0.45 meters to 0.9 meters. The as-built the as-built rear yard canopy is the side yard setback is 0.16 meters, which is in line with the existing side yard setback of the north side of the property. And that is variance number 2. The rear yard canopy was constructed to protect the existing rear yard deck wheelchair elevating platform from precipitation, whereas the rear yard hard surface area was introduced to allow unencumbered wheelchair access to the rear yard. I'm happy to answer any of the questions that the committee may have or any opposition.
Okay, so is it correct that the person who was disabled and used the chairlift and the canopy, etc., and the access ramp, and why the backyard was all concreted, is that person has died, as I understand it?
Correct, Mr. Chair, that owner, Mr. Francisco, has passed. He passed away subsequent to the zoning application being filed, but prior to the Committee of Adjustment application, which came after the zoning review application.
So is it necessary? So you have 0 soft landscaping.
Correct.
Yeah, and we're always looking to increase landscaping and soft landscaping. So is it necessary to maintain the chairlift and the access ramp and the concrete backyard?
The access ramp is no longer required. However, that would still be a walkway to the garage, so it would still be hard surface. The concrete in the rear yard, a suggestion that I would make to the committee, if you pull up the survey of the property, the north side of the actual wood ramp that's shown there, there's an area there on the north side of the ramp between the garage and where the canopy is. It's sort of marked off there. It showed the edge of one concrete to the edge of the other concrete on the north side of the ramp. We could propose to have that concrete removed and replaced with soft landscaping in that area.
Okay, and how much would that increase the soft landscaping?
That would introduce soft landscaping of approximately 15.8 square meters or 14% of the rear yard area.
Mr. Rodriguez, did you say 14%?
14%, 15.8 square meters.
Yeah, thank you. So is your clients prepared to do that, I take it?
Should the committee require the soft landscaping, we're just trying to not introduce any additional cost to her at this time. But if as a requirement of approval, that's something that she can undertake to have done.
Yeah, no, certainly that's, if the application is approved, that's going to be one of the requirements, I'm sure. So, Carl, do you have a question?
Thank you, Mr. Chairman. Could the applicant clarify the area he's talking about putting soft landscaping in? Does he mean there's a site plan? Well, no, leave the site plan on the screen. So is he talking? Are you to the applicant, are you talking about the space from the wood ramp going up to the property line, or the wood ramp going down to the property line? Because I frankly, even if there was still a handicapped client, I don't see any reason why the backyard from the base of the stairs, almost from the base of the stairs through to the full width of the property, with the exception of a ramp, couldn't be soft landscaping. I just don't see why. I don't understand why you can't comply with the bylaw.
Through you, Mr. Chair, to the committee member, the area that I'm referring to is north of the ramp. So from the ramp up to the property line to number 23. So that area that's enclosed, that's a rectangular area there, which encompasses that number 137.77 as the elevation. So north of that ramp there, that would give me an approximate 14% of the rear yard. Now, south of the ramp, the hard surface there, it's used to store the garbage bins, which go up and down the side of the property on garbage pickup day. So she would take the exterior garbage containers and roll them from there up to the front of the property, right? That's where they're stored right now. You can see that through submissions made from the neighbor at number 23, through pictures that she has submitted, that's where the garbage containers are being stored right now against the garage on that concrete area. So what we're proposing in terms of introduction of soft landscaping is that area north of the ramp or access way, because the ramp is no longer required either. But there would be a hard surface access way that provides access to the existing rear man door in the garage, which is shown as the same width of that 1 meter strip from on the access way. So anything north of that is what we would.
Not to make too fine a point of it, and also to save us all some time, if the ramp isn't there, then the location of the ramp, that specific location is somewhat immaterial. So you could in fact increase that area you're proposing for soft landscaping if the area that's below the ramp on this drawing is where she stores her garbage. You can store the garbage in considerably less space than is shown there. I guess I'm arguing that you could do a lot better than 14%.
Okay, well, with respect, through you, Mr. Chair, to the member, the rear man door to the garage is located in that area. So, you know, you could maybe move the hard surface area and shift it, but then you'd have to walk in a northerly fashion up and across, right? The garbage bins are stored up against the garage door, so, or the garage wall. So there may be some room to get something better than 14%, but keep in mind that this number of 25% is for the whole rear yard area, which is from the rear yard of the building to the laneway. Take away from that the area of the garage, take away from that the area of the deck, the basement entrance, and the driveway behind the garage. You're really not left with something that you can bring it up to 25% very easily, right? Without having, you know, you need a walkway from the house to the garage as well. So what we're proposing here, I believe, is giving back something which is even greater than what was originally approved when the house was done under the previous bylaw, which didn't regulate soft landscaping in the rear yard, just regulated landscaping, and landscaping included hard surface.
Ron?
Yeah, I have a question about the chairlift. Is that chairlift still there? Because I think we received a letter which might have said that chairlift is no longer there.
No, the objection letter stated that the ramp was removed, which, according to the picture that she submitted, the ramp has been removed. I do not know if the chairlift has been removed as of yet. As we've reported to the committee, the owner has passed away, so the use or the requirement for the chairlift is no longer there. But regardless of whether the chairlift is there or not, it's underneath the canopy. So I don't know.
And so that canopy, why do you need such a large canopy if the chairlift is no longer needed and the ramp, like I'm trying to understand that. Seems like a very large canopy.
Well, the canopy covers the rear deck and basement entrance area, and it was put in place to protect the owner there when he was using that as access to get in and out of the building to go outside. That's what the canopy is. So the canopy exists. It's not that something that we're proposing. We may be looking at something different. What we're trying to achieve here is just the minor variance with respect to the canopy is only dealing with the side yard setback on the north side. It's not dealing with anything else with respect to height, massing, size of the canopy. It's only to the north side yard setback, which is in line with the building at 0.16 meters, and whereas the bylaw requirement is 0.45 meters. So what we're talking about is a 0.3 meter shift or setback on the north side, which is a foot, right? So that's the only difference that in terms of variance for that canopy.
And does that canopy have any siding on it, like any tarp or siding?
Well, right now there's a tarp on it. The construction hasn't been finished because there was an order to comply that was issued, and we've gone through the process to try and regularize and legalize the construction that was there. That construction will be finished. There will be no side wall to the canopy. It's just there to protect it right now in terms of weather and where things are, because the structure has not been completed. So the only thing that may or may not be put on that sidewall is maybe a curtain of some sort, just to deal with wind or privacy or anything in that vein. There will not be any permanent structure on the sidewall of that canopy, as the drawings indicate, right? So
can I clarify on the purpose then, based on Nimrod's questions? It says to maintain the rear canopy. Okay, so the canopy's there. The vertical stair lift, well, it doesn't sound like you need it, so why would you need to maintain it? And the access ramp, which you say is already gone.
Mm-hmm. So with respect to the description, that's not something that we've put together. That's something that comes from the committee. The application went in that regard. There is no variance associated with the chairlift, whether it's there or not. And there is no variance associated with the ramp, save and except for your rear yard soft landscaping. So, I'm sure the chairlift is going to be removed, but at the time that the application was filed, the chairlift was very much required. So,
if you remove the chairlift, how much more would you get in terms of soft landscaping?
That chairlift is underneath the canopy. So if you're looking for soft landscaping underneath the canopy, that's something that could be provided in that area, but it's underneath a roof structure.
Can I ask a question, please?
Yes, Yim.
Yeah, I don't want to make this up, but because I just want to know, in one of the letters we received saying that all this paving, the concrete paving, only occurred very recently. Is this last year? Is that true?
Well, the concrete paving would have come as a result of the owner being bound to the wheelchair. The date on the order to
No, we know that part that he passed, but I'm asking if it is a newly paved backyard, right? It was only paved last year.
I think it might have been 2020 or 2021, not last year, because the order predates that, right? So it would be that area, as I referred to, that is from the wood ramp north to the property line that was paved. Everything else before was hard surface. So only the area that I'm suggesting that we put back to soft landscaping.
When that backyard was paved, was a building permit obtained for that work?
No,
My
there was no
difficulty is you're asking us to look at something that is very recently built without a permit, and I do not consider that is existing because it's a change of existing condition. And now we're looking at 0% loss of landscaping, and yet you call it existing, but it's actually very recently changed from something else.
Yes.
Right?
Yes. No, I appreciate that. I refer to it as built. It's not existing. That portion that's concrete on the other side, and that's from the survey and whatnot. It is concrete at the time of the survey. Now, the letter of objection here, you can see as to what areas are hard surface. And the neighbor themselves at number 23 have a very large area of their rear yard, which is also hard surface as well, which a permit wasn't obtained for, but I'm not too sure that they're in compliance with the bylaw or not, but that's not material to our application. What we're trying to provide is to bring to get some relief from the bylaw with respect really only to the side yard setbacks in this area, soft landscaping, to make it a better situation than what was originally approved under building permit back in the late 90s. So what we would suggest is to put that area on the north side of the access to that door in the rear garage, all the way to the fence line, up to the edge of the canopy as shown on that survey there, as soft landscaping in lieu of the concrete that's there right now.
Okay. Anila Gupta and Natalie Wood.
Hello, can you hear me?
Yes, we can.
Hi. My partner here is sitting with me, Natalie Wood. We're the owners to the north of the property in dispute. We are
And
the
your
ones who are-
address? Your
Oh,
address
sorry,
is?
23 McRoberts Avenue.
Thank you.
23 McRoberts Avenue. We've lived there for over 18 years. We've enjoyed our garden. We recently had to reconfigure the backyard because of the problems we were having with these with the irregular builds without permits that our neighbor had completed without a permit. So I'm a little nervous. We have massive garden beds, so I just want to respond to that. We actually have massive garden beds. We have over 20 feet garden beds that are 5 feet by 20 on one side, and I don't know, 3 different garden beds on the other north, the south, yeah, the most north-south side. And we also have many, many potted plants. But anyways, it's not about us. It's about what our neighbors have done without a permit. The monster canopy has had a major impact on our ability to enjoy our backyard because of its mass, its scale, and the fact that it actually does obstruct our sunlight, our feeling of openness, our view, and our ability to have air circulation. It extends, as you can see, the entire width of their house and actually further into the side yard encroachment. So it actually extends past their north wall. It's over 14 feet height. It extends from the ground to their second floor. And its depth is probably 11 feet. So it's a huge eyesore, and they've also enclosed it, and they do have a history of enclosing. In fact, before they deconstructed all of their other sheds and so forth, we were actually getting more light because it wasn't as high up. So they have a history of building without permits. We feel like we're living in a tent encampment, not a backyard. And according to our realtor, this is going to hurt our property values. So we have a real problem with that. Our enjoyment of our backyard has decreased. Nothing grows anymore closest to the south side of our garden. We only grow moss, and we that area is perpetually soggy. And it used to be that we had flowering bushes, we had to pull them out. So I have lost hundreds and hundreds of dollars on our landscaping. So I object to the variance number 2 in terms of the side yard setback. I don't understand why there isn't a variance that is being requested for the actual canopy itself, which is acting as a second roof. so I'm also objecting, of course, I think you have no problems with the fact that the entire area has been paved and you feel that that should be addressed in terms of soft landscaping. I agree with you on that. In terms of most people don't actually have a backyard deck or a canopy. They usually go onto their ground and use an umbrella to enjoy their backyard because they actually have very short backyards. Our yard, we actually had a architect build and extend our house, but even then we are still set back. So while we have some shade because of the house and the neighbor to the further south side, we still got sun, and we have lost what little sun, what sun we did get. We have absolutely no sun, and it is really destroying our appreciation for our backyard, which we use every day of the summer and into the fall and the winter. So it's not in keeping with the character of the neighborhood and the intent of the zoning bylaws and official plans. I don't think there's a reason why it's not reasonable to have such a large canopy. They can put a canopy on top of their deck. But I don't know why they really need a canopy that extends all the way to our side. And if they're going to have a basement unit and a side yard entrance, a side
Entrance, yeah.
door, there's no reason why they can't get rid of their backyard stairs or make it into a window egress. And therefore, if they have a concern about water and snow, that's not good enough. Most people shovel out their backyard stairs if they even have them. Most people don't have backyard stairs into the basement. Thank you. Should I just
Thank you.
stop or
Any-
can I continue?
Just
So
to
we would
reiterate,
like it removed, just to summarize, we would like the rear canopy. It was not existing. It was put up without a permit just last year or the year and a half before. It's a visual block to our sunlight, air. It's an eyesore. It's a potential fire hazard.
damage,
And we want it removed so we can enjoy our backyard again.
not sure.
The stated justification for that build is no longer applicable. And we would like at least 25% of the yard back to soft landscaping so we don't get flooded. It's a danger for us in terms of our slip hazards. And because it ices over now, where before it would melt. So sorry,
All
I
right,
was
Ms.
nervous.
Wood, your time is up. If you could just
Yes,
wrap up.
thank you very much. That's it.
We're done.
We're
Thank
done.
you.
Thank you. Thank you for your attention.
So panel, do you have any questions? Okay, Mr. Rodriguez?
And can you hear me? Sorry.
Mr. Rodriguez?
Sorry. Can you hear me?
Yes.
Sorry, Mr. Chair. Yes, in response to the comments from the neighbors at number 23, the canopy is constructed in line with the house on the north side. The overhang is what protrudes from the side of the wall in the same fashion as the overhang of the entire house protrudes from the north wall. But the canopy is constructed in line with the north side of the building, which can be demonstrated there on our drawings that were submitted that you're looking at on the screen, and also on the survey, which locates the location of that column, which is the last support on that canopy. There are no variances requested with respect to height or massing on the canopy. The only variance that is being requested for the canopy is that north side yard setback. And again, that is just being maintained with the existing north side yard setback of the dwelling. We are prepared to allow that patch of the 14 square meters or 15.8 square meters of 14% of the rear yard area to introduce soft landscaping adjacent to the property line between the subject property and the objecting neighbors at number 23, which should alleviate a lot of their concerns with respect to runoff and stormwaters. What this application is doing is trying to regularize or legalize some construction that was commenced without a permit to assist with the neighbors' needs at their time of the end of life. And we're just trying to now regularize that construction to the best of our abilities and make a proposal that is, in our opinion, very minor with respect to that setback being in line with an existing setback and in keeping with the character and fabric of the neighborhood. Most of these rear yards are all hard landscaping, and I'd be hard pressed to say that number 23 does not have 25% of their rear yard as soft landscaping, and I find it interesting that they are complaining about the neighbor here. So those are my responses to their concerns, and I'm more than happy to answer any other questions that the committee may have.
So, sir, you were asking us to permit rear canopy, vertical chairlift, and access ramp, which are no longer required. You said you made the application before.
Sorry, the zoning application was made prior to Mr. Francisco's death.
Yes, I understand.
And the process was done, and the construction was obviously done prior to that. But subsequent to his death, we continue with the application because we're dealing with the order to comply and trying to get a permit for the construction that has been commenced.
But there's no longer a need for any of these things.
Well, the canopy is there to cover that rear deck. Like I said, the chairlift is going to leave if it hasn't left already, and there's no variance associated with the chairlift. There's no variance associated in that regard. The variance is with respect to the rear canopy itself and its proximity to the northern lot line between 21 and 23, and the rear canopy on that side is in line with the house. The width of the canopy is the width of the rear of the house. And what we're trying to do is just maintain that access, to maintain the canopy that has been provided as shelter for the existing basement entrance at the rear, the existing rear wooden deck.
You need the same size canopy to shelter the walkout?
Well, the canopy does cover the walkout and cover the deck. What we're trying to do is just to maintain it in the size and scale that it is, to try and avoid any further costs to the homeowner at this time. Like I mentioned to the committee before, if the northmost column is moved 12 inches to the south, there is no variance required for that canopy. So we're talking about a side yard setback of 0.16 meters in lieu of the required 0.45 meters, which is clearly spelled out on the zoning review as well as to what the requirement is for that canopy. So it's about a 12-inch setback on that north side. So the question is, does that cost, is that cost something that should be encumbered on the owner, or is that a minor variance to the requirement of the bylaw?
Okay, thank you. Carl, you had a question?
I was going to ask if a zoning review had been done, but the applicant seems to have indicated that in his comments to you.
Oh, okay. Any other questions? Okay. Do we have any comments, or do we have a motion? Yes, Carl.
Thank you, Mr. Chairman. I am, notwithstanding the architectural consultant's attempts, I am not convinced by this application. I have lots of areas of concern. I don't think digging up a portion of the paving and getting to 14% is good enough. It seems to me, as Jim said, it's recent paving. I don't think there's any reason for this backyard not to comply with the zoning bylaw. And I also have trouble with the purpose of the application, to maintain the canopy. I don't really think there's been justification shown for a canopy of that size and in that location. The vertical chair lift, as has been indicated, might go, so I don't know why we'd maintain that. The access ramp is gone. All things considered, Mr. Chairman, I'm not prepared to support this application.
Okay, is it here?
Thank you, Mr. Chair. Thank you to Carl, because I think I'm of similar mind. What also added an image to me that made up my mind, and I suppose in a sense was the photographs that were presented. It's difficult sometimes to recognize just how small these properties are, and then having this gigantic canopy. And if the purpose says to maintain it, we would be authorizing it to be maintained. And I can't quite get my head around that one. And the variance number 3 is one I couldn't approve. So I will not be supporting this either.
Kim?
I sort of agree for with both of them. I'm a little bit more lenient, I guess. I was just going to refuse variance number 3, because the reason for that is that the only one fact is already been done. It's not a good reason that we should approve 0 loss of landscaping. And the applicant has argued that. Sorry, I have a candy in my mouth. Argue that they don't want to incur extra costs, but the fact is they put in a lot of money when they're paving this area too. And it didn't occur to them to apply for permit. Maybe they save a lot of money at the end. So I can support the application, but refuse variance number 3. But if the motion is to refuse, I also can go with that too. Yeah.
So, Yim, what is your position with respect to maintaining the canopy and the vertical chairlift and the access ramp? I think the rear canopy is a real issue.
You're right. I wasn't thinking too much about it until I see the photographs and I hear the impact it creates to the next door neighbor, and it's quite unnecessary if they actually have applied for permit, and then maybe the issue has been addressed or mitigated by moving it a little bit or reduce the size or the height or whatnot. But it's already been built. It's very difficult. So now I'm thinking about it. I will tend to refuse the application after. Yeah.
With
It's not good reason
respect,
to.
Mr. Chairman, if I could make a suggestion, I don't know.
Are we in committee, Mr. Chair?
Yes, we're in committee.
Yeah, okay.
All right, Nimrod, did you have something?
And my comment is I agree with all the comments, and I'm going to support refusal of this application.
Carl?
Mr. Chairman, I'd like to bring a motion to refuse the application.
Have a seconder? Yes, here. All in favor of refusal? Application's refused. Thank you. Number 27. (877) Coxwell Avenue. The purpose of this application is to alter the existing one-story detached dwelling by constructing a complete second-story addition with a ground floor covered front porch, second floor covered front balcony, rear ground floor deck, and a new flat roof for the existing attached garage. With this application, we have material submitted by the applicant. We have correspondence from planning and a report from urban forestry and a 2-signature petition in support by owners on Coxwell Avenue.
Hi, good afternoon, Mr. Chairman and the committee. My name is Vladimir Persik. I'm the owner of 877 Coxwell. So what we would like to do is to build the second story and to renovate our bungalow to give us more living space here. This is pretty much similar to what other neighbors are doing. It's actually somewhat smaller than the build that was just approved less than a month ago to our south side at 875 COXWELL. So in this application, we're just building straight up above the existing footprint of the house, with the balcony being above the existing stoop that is in the house. And one thing that I want to add, if you can't enlarge that a little bit, when I talked to the builder last week and asked him for explanation about the variance number 7, you could see that it's clearly that we are adding a little bit of soft padding by having a shorter path to the driveway rather than this long diagonal path that is existing today. And I asked him to explain him the measurement, which then he stated that variance number 7 should be removed, as the correct calculation for the soft padding should be 24.36 square meters, which is the above of minimum required 21.02.
So you're agreeable to eliminating variance number 7?
Correct.
Okay, do you have anything else you wanted to say?
No, the rear deck, actually there is existing rear deck that is built on the top of the old cinder block. So what we would like to do is just to replace that rear deck and modernize it.
Okay, thank you. All right. Kim, do you have a question?
Just a very quick one, because you have submitted a revised site plan. Can you tell us very briefly what's been revised or what's different from the original site plan?
Is that the confirmation just did about this green space, soft padding?
Just the green space has been revised, right? That's the only
Oh, yeah. If you can zoom out, sorry, make it larger. If you look at the width of the proposed green space, which is already green space today, is 3.78 meters. And the length of that is obviously from this, there is no measurement here in this. It's obviously much larger than that. It's actually 6.4 meters. When you multiply these two, you get about 24 square meters rather than stated in this application that is 10.75 meters. And you can see from this that this new path that we propose is much shorter than the long one that is going. And the reason why we did it is actually to stay away as far as we can from the city tree, that is fairly large city tree in front of our house.
Okay. So it's okay if we tie the approval to this revised site plan? Yeah?
Yeah.
Okay.
Okay, any further questions? Carl?
Thank you, Mr. Chairman. The planning department has suggested that you screen the balcony on the front of the house, and I'm questioning that because it would tend to make the house look bigger. It would make the porch look like a rather large piece of the house. How do you feel about screening that balcony on the front?
I would say that actually, we discussed our plan with the neighbors to our south. Actually, we wanted to hear their experience from the committee, and they told us, obviously, we know what we are doing. We support your application. In essence, the view that they have from that balcony is obstructed by a very large tree most of the year anyway. And actually, all that they could see from that balcony is their driveway on the south side. And actually, it's the same view that they have from the bedroom that is on the second floor. It's not really different. So I'm not really sure what that privacy screen would achieve.
Okay, I'm inclined to agree with you. If I live next door to you, I would prefer to not have the screen in that location as well. So thank you.
Thanks.
So, committee, do we have any comments or do we have a? Yes, Nimrod?
Yeah, I support the revised application and the removal of variance number 7. So that way the front yard the soft landscaping has improved significantly. That variance is no longer needed. I would agree that it's better not to have screening at the front balcony. I think it would make it look more imposing. And so I would move approval of the variances subject to urban forestry number 1.
All right, Carl, you second that?
Yes.
All in favor?
And that says the amended application.
Yeah. Favor? Approval, sir. You. Number 28. 156 Grenadier Road. The purpose of the application is to alter the existing 2.5-story detached dwelling by constructing a 3rd-story dormer, a covered front porch, and a rear ground floor deck. With this application, we have materials submitted by the applicant and a report from Urban Forestry. Mr. Asimovic.
Good afternoon, Mr. Chair. My name is Dan Achimowicz. I'm calling you from DA Design here. We're located 1185 Queensway in Mississauga.
Okay, we need a brief presentation, sir, because there is opposition.
Absolutely, no problem. If I can start, if you can please scroll over to the actual survey, which is page number 2 in my drawing package. Yep, and if you can please zoom in on the house, specifically at the back of the existing home. One of the the first drawing. Yep, the very first one. Yep, that one. Sorry, that survey right there. If you can please zoom in on that. At the back of this property, you will see that there is a small bump out at the back of the home. For once, I'm actually coming in with a smaller home. This is a 2-story bump out at the back of the home, and we're actually removing this 2-story at the back of the existing 3-story home. So that's one of the first items I wanted to cover. Regarding the variances, I can quickly go over those. Variance number 1 talks about the dormer on the west side, which in this case here would be on the, in here, it would be on the right-hand side. So you can see the light gray on top of the existing home footprint that you see there. That light gray is the extent of the dormer, and that item there is causing us a couple of the variances. Again, we're shrinking the home where the existing 2-story is at the back of this property, which is at the top of this diagram. We're proposing an outdoor deck. So item number 1 talks about the distance from the dormer from the right or west property line. It is at 0.67. Basically, that dormer is located on top of the existing wall. So we're not extending past the house west side, but we are required to be 0.9. Item number 2 deals with the required front yard setback of 3.64. If you can zoom in on this site plan, just at the front, the little box that's sticking out there, we basically filled in the existing front porch and made it a habitable area. So we didn't expand past the existing footprint, but once again, you can see just how small, how shallow this front yard is. So we're at 1.99 to the front face of the existing building, and that's going to be a 1-story. A platform, item number 3, without main walls. So this is dealing with the platform. Items 3 and 7 basically are the front deck. So you can see it, a proposed composite covered porch. You can see that item at the very front on the left-hand side. We're 0.19 meters from the east property line with the deck itself, and then the stairs themselves are also, which is item number 7, are also 0.19 from that property line. So that's items 3 and 7. Items 4 deals with the width of the dormer, so back to that light gray area. We did make that dormer a little bit wider than approved or approvable, if you will. At 40% is what's approved. We're at 47%. And the only reason we did that is that dormer covers this new staircase that's running up in the center of the house. We wanted a little bit more headroom, and we also wanted a little bit more headroom on that third floor in particular. If you'll notice, the actual existing roof is the same slope, so we did not expand it except for that gray area. So that was the reason why it's a little bit bigger than allowable. Item number 5, again, it deals with the floor space index. Once again, we shrank the house, so we've actually improved the existing FSI. Item number 6 deals with the exterior stairs providing pedestrians. So that's the steps at the front of the house. We did make them 3 meters wide. We're expecting people to sit on those, watch the, people going by. The sidewalk is right there, and it's a very urban type of a setting. So we're kind of hoping to accentuate that feel of the city. And then the final item is item number 8, deals with the maximum 30% of the side exterior main walls may be higher. Once again, this is the dormer on the west side. So the height of that dormer, because we wanted a full ceiling height in that space, is at 9.5 instead of the allowable 8.5 meters. Yeah, and then further from that, I have 29 seconds here. Basically, items 4 and 8 are better explained on pages A2.9 and 8.37. If you want me to, we can go to those pages, but I'm not sure if I have time to do so.
Okay, thank you, sir. Any questions, panel? Okay. Nav Tekar.
And thank you, Mr. Chair and members of the committee. Thank you for giving me the opportunity to comment. I'm at 130 Grenadier Road, which is directly across the street from this proposed minor variance on this property. And firstly, I would like to argue that these variances may be taken in isolation or minor, but we have not 1, not 2, not 3. We have 4, 5, 6, 7, 8 variances that are being applied for. And I know the gentleman who presented really liked to use the adjective of small box and little. But if you go through each of them, the first one, variance number 1, they're asking for a 35% encroachment on the west side. Variance 2 is a 50% closer to the north side. Variance 3 is 20% closer to the east side. And it goes on and on. And by looking at it, it looks like they're increasing the house on all fronts, in all directions. I find the most interesting one is variance number 3, where they're proposing the final structure is a paltry 19 centimeters from their eastmost neighbor. I think what's happening here is, so that these are new owners on this property, and I think they're attempting to kind of shoehorn their own design aesthetic and their own plans into a property, into a lot and a property that just are not able to accommodate them, which really begs the question, if the only purpose of these variances is aesthetic, then why can they not just comply with what those laws are? And also, if the owners are arguing, oh, we need the space to live in, because contrary to what the presenter said, yes, they might be knocking down a falling down little extension, which is more of a lean-to in the back. Clearly, I'm looking at the facts here, and requested variance number 5 is that they are actually increasing what is permitted on the lot by 20%, irrespective of what it went from. The fact remains they are increasing by 20%. Why don't I suggest this to the owners of this new property? Why not do something that can increase your square footage, by 30 to 40%, and that is construct a laneway house. Because you can construct a laneway house without going to any committee of adjustment. You can construct a laneway house by adhering to the bylaws, the rules that are in place, and you can have more room for your family as well. I do argue that all of these variances, as I said, in taken in isolation are minor, but when you have 8 variances pushing this property out past on every direction, I would argue that these are not in the totality is not a minor variance. Thank you very much.
Thank you. Serge and Rosemary Delic.
Serge and Rosemary, you've been unmuted.
Your recording has reached maximum length. If you are satisfied with your message, press 1.
Pardon? Okay. All right. Herb Forrest and Karen Black.
Karen, you've been unmuted.
This is Karen Black speaking. I live at 132 Grenadier, almost directly across the street from 155. And I'll just start by saying, I guess we don't really understand why the renovation has been designed so that there has to be a request for so many variances. But we're particularly concerned about the request number 3, to change the setback, because of course it changes the setback by about 50%. And there's no other house on the street that has changed their setback from a renovation. And I noticed that the presenter called the extension of the house a covered porch, but I think it really just presents as an extension of the house, bringing it 50% closer to the lot line. So that's my concern.
Okay, thank you. Have the Delics now, John?
Serge, you've been unmuted. Serge and Rosemary Delic, you've been unmuted. You can speak now.
Mr. Delic? Oh, okay, we got to move on. Mr. Asimovic?
Yes, sir.
So, can you
yeah,
just...
I mean, just in response to the commentary that I heard,
Yes.
I am a little bit surprised about the comments that were made by the neighboring. I'm not quite sure if they fully understand basically the design set, but from our perspective, we have literally shrunken the house. We have reduced GFA, we have reduced FSI, we have not expanded in any way. So for anyone to sort of approach this application is something that's extraordinary from a size scale perspective. Yes, the percentages are greater than what is allowable, and I agree with that, but you have to understand that this is an old existing home sitting on a small site. No matter what we did to this property, it would have triggered numerous variances. Unfortunately, this has added up to a list of 8. But once again, there's literally, I don't think anything that we could possibly do that would have reduced the number of variances from the moment that we touched this project. And the other comments that the owners has told me that there's no opposition from the immediate neighbors, which I think is the most left and right, which I think is the most, sort of the most important people on the street. Obviously, the other people on the street are as important, but from my perspective, that's who really matters. There are other additions on this street, numerous projects, and the owner did think about putting in a laneway house. That was absolutely considered, but once again, when we did the design for the laneway house, it triggered a whole bunch of other variances, and for that reason, we said, let's work on the house and let's get the space that you need and get approval for that. Okay.
Okay, Mr. Asimovic, I just want to clarify some things. I understand that you're saying we didn't enlarge the house, we shrunk it. But and I agree with you that I think some of the neighbors are misinterpreting what some of these variances are. So for example, number 3, front platform located 0.19 meters from the side east lot line. Is that the existing distance from the lot line?
So no, that's part of our current proposed design. So if you could, please go to the cover page with the images of the front rendering. That would be the easiest place to explain these 2 variances for, yep, that one right there with the triangular window at the top. If you can please zoom in on that front covered porch on the left-hand side. Yeah, basically that's what we're referring to here. So you can see that platform. So item number 3 literally deals with the platform at that front entrance being 0.19 meters from the property line. Again, the edge of the house is at that same amount. In fact, it's even a little bit closer. And then item number 7 is the same issue. The stairs that we designed right across the entire platform is also 0.19. Those are items number 3 and 7.
So it's only the stairs that are closer.
The stair and the platform. If you read the text in items number 3 refers to the platform without main walls. So that's basically the front porch. And item 7 literally deals with just the stairs.
So the floor space index, 0.72, is that larger or smaller than it was previously?
Smaller. Yeah, we're literally deducting 2 stories at the back of the house. So the FSI would have been higher if we had left those. Now we took them off because I think one of the neighbors mentioned they're not in great condition, and the owner wanted, a modernized home and, cost and things like that. So we literally reduced the FSI, reduced the GFA of this home.
Thank you. Any further questions? Carl?
Thank you, Mr. Chairman. I had some discussions with staff when the agenda came out because I think the purpose of the application is not accurate. If you look at drawing A2.7, and I don't know if that could be put up on the screen, and I believe the applicant's been party of these discussions, so none of this will be new to him. I just wanted to clarify something. Okay, can we scroll up a bit? The other way, sorry. There. Normally, when you enclose a porch, what we refer to is you're putting some glass around the porch to prevent wind from getting on it or rain and so forth. In this case, it's somewhat different. I would argue that this is a front addition because where the porch used to be is now an extension of the living room. So in fact, it's habitable space, and I would argue that that's a front addition. I don't have any difficulty with it, but I don't think the purpose is explaining that correctly. I don't think this is just simply an enclosed front porch. I think it's actually extending the living room further out into the front yard. And that's what one of the ladies that was speaking in opposition was referring to. So as I said, I don't have a difficulty what he's proposing to do. I think it's reasonable, but I don't think the purpose as it's worded clearly identifies what the application is. And I believe Nicole from the city has been talking to the applicant about this and suggested a rewording for the purpose, and or the deputy secretary treasurer might have a suggestion. But I don't think saying that that's a front porch enclosure, I don't think that's correct.
Through the chair, we can amend the description to reflect that the existing front porch enclosure will be reconstructed and converted into habitable space. That will capture the extension.
Yeah. That's great. Thanks.
Okay, any further questions? Zahir? You're muted, Zahir.
Are we in committee now? Sorry.
Yeah.
I didn't hear you.
All right, Yim,
Sorry.
Zahir's supposed to be
He's
saying
going to make a
something.
comment. Okay, I make my comment after you. Okay.
Yes.
Thank you. I was just going to, from what I can see, there's no structural change to the main structure of the home. It's not exceeding the existing footprint. So there's nothing really that is fundamentally changing in terms of the size and shape of the house, with the exception of the dormer, which I think is always useful, habitable space. So in terms of the renderings that I see, I think this is quite an improvement over what's existing. I definitely have no concerns about this application at all, and I take into account Carl's point about the purpose, and what if the purpose is changed accordingly. I think this is quite a novel, and not necessarily a novel, but a good addition to the neighborhood.
Yim?
Okay, it's my turn, right? I want to add the comments that I really appreciate the presentation, and also it's very clear. And I think that is an excellent design in terms of making some changes without just automatically making the house bigger, but it's improving the functions of the house and the habitable space that's stealing from different little change. I think it is a very sensitive, well thought out design. I listened to the opposition. It seems that they fix on the numbers and also the variances, but they have not given me enough evidence that the real impact that they see from they get from this the development. There's almost no mention of the impact that they will have, and other than the fact that the numbers seem to be increased or the number of variances. So I'm fully in support of this application with Kyle's suggestion of changing the purpose clause, and also the forestry condition number 1. I will be supporting.
Okay, so that's your motion?
Okay, I'll make a motion with condition forestry condition number 1, and also amend the purpose clause as suggested. Yeah.
Thank you, Zahir. You second the motion?
Yes, I am,
All
Chair.
in favor? Have your approval, sir. Thank you. Number 29, 125 Danforth Avenue. Purpose of this application is to convert the existing 3-story building into a mixed-use building by constructing a rear 3-story addition and 2-story addition above the 1-story portion of the building. A total of 8 residential dwelling units will be provided on the 2nd and 3rd floors. The existing on the ground floor will be maintained. We have materials submitted by the applicant, and we have a report from community planning. Slobodan Vlahovic.
Can you hear me?
Slobodan, you may want to speak a little bit louder.
Am I coming through?
Not very well.
As long as I can speak.
Perhaps you could speak closer to the microphone and a little louder.
Let's see. I'm at 100% on my microphone. I don't know what's wrong with it. I'm representing my client. He would like to increase the usability of his building and increase the quantity of apartments in the building. Originally, it was built with retail on the ground floor and apartments on the 2 upper floors. In over 50 years, that has gone from apartments to commercial rental, back and forth. And now they've decided that it'd be better to just stick with residential units.
Right, sir, Mr. Vlahovic, can we
Yes.
just have your name and address?
Oh,
for
I'm
the
sorry.
record?
My name is Slobodan Vlahovic. I'm at 8 Onaway Road, Mississauga. I'm the
Okay.
representative of the owners.
Yes, thank you. Go ahead.
Okay, so the biggest issue I see in this and from the requested variances is that there isn't any parking. And this particular property, really no parking can be available. You can get access to the back. It's very narrow, it's narrow, but you can't put a legal parking spot anywhere on the property without blocking the neighbors. All the neighbors to the west and south rely on that access for their servicing of their units. So there is parking, but it's ad hoc and not what the city would, indicate as legal. That's basically it.
Okay, thank you. Panel, any questions? Okay, let's go to Mr. Casarabias.
Mr. Chairman, is anyone speaking? I can't hear anything.
That's because nobody's
message and phone
speaking
number,
now.
and I'll get back to you as soon as possible.
We're waiting, I think.
Gerardo, you've been unmuted.
Is he there?
Gerardo, you've been unmuted.
Yeah. Hello.
Can answer the phone. Please leave your message and phone number, and I'll get back.
Okay, can't get through. All right. So, panel, any now, do you have any comments or do we have a motion? Yes, Carl.
Thank you, Mr. Chairman. This is a terrific application. It's a great location for additional housing. I have no difficulty at all in supporting this. There is a suggestion from or a condition from the planning department which limits variance number 3 somewhat, but other than that, I would have no trouble at all in supporting this application. I'm really glad to see additional housing in this location.
Okay, is it here? You're muted, Zahir.
I think this is a very good application as well as just echoing Carl. And the issue of parking shouldn't be a problem at all. This is Danforth, and Danforth has fantastic access to public transit, so it's a totally supportable application.
Right across the road almost too from the Broadview subway station.
Oh, excellent.
Okay, so we have a motion, Carl.
Yes, Mr. Chairman, I'd like to move approval of the application subject to the planning condition that's in the added materials that we have today.
You second that, Zahir?
Yes, sir.
All right, all in favor? Have your approval, thank you. Number 30, 766 Logan Avenue. Purpose of this application is to alter the existing 3-story semi-detached dwelling by constructing a partial rear 3rd floor addition and a new rear ground level deck. With this application, we have material submitted by the applicant, a report from Urban Forestry, and 5 form letters in support. Mr. Galbraith.
Good afternoon. Sean
Good
Galbraith,
afternoon.
planner here on behalf of the application.
And your address, Mr. Galbraith?
18 King Street East, Suite 1400, Toronto.
Okay. So this is pretty straightforward. I don't think we need presentation.
The FSI is a 0.01 increase over the existing, and the existing soft landscaping is only 24%, so that's being increased notwithstanding the variance. And if permeable pavers are wished for, we're happy to do that.
Okay, your wishes are command. Okay, panels, Carl?
Sean, can you explain the difference between the original site plan and the revised site plan? What's changed?
We increased the amount of soft landscaping, if I remember right.
It's the black, the area that's black on the site plan, right?
Yeah,
Oh,
that's
yeah,
that.
here.
Yeah, that's
Yeah, when
it's
you
yeah, it's the hatch pattern.
when you make it larger, the hatching comes up. Yeah, thanks.
Precisely, yes. I went back to the architect to ensure that they could maximize the amount of soft landscaping back there, and they were able to squeeze in some more.
That's great.
Okay, where do you suggest permeable paving?
I think there are. I would say permeable paver as a condition, permeable pavers where possible, perhaps.
Where?
I think there's the non-hatched area is hardscape. So if there's like walkways and such.
So there's walkways, there's paving all the way around the green area. So you're suggesting
It's more gravel. That's the existing condition.
okay, so so you're saying some of that might be permeable pavers if it's gravel, it doesn't need to be because the water still goes through it.
Yeah, it would be nice if the calculation would include that, but unfortunately it doesn't.
No, it doesn't.
I mean,
No.
if you don't see fit to do, if it'd be more complicated to include that as a condition, we're certainly happy not to have it.
Well, I think we would, have to locate, designate a specific area or a specific amount of it. And it seems to me, as Carl said, gravel and permeable pavers are not much different. So
it might be just overcomplicating things.
Yeah, I think so.
Okay.
Okay. All right. So panel, we're in committee comments, or do we have a motion? Nimrod?
Yeah, I think that the variances before us are minor in nature, and I would move approval of the variances subject to urban forestry condition number 2.
Thank you. Seconder Yim, all in favor? You have your approval. Thank you. Number 31. .307 Willow Avenue. The purpose of this application is to alter the existing 2.5-story semi-detached dwelling by constructing a rear 1-story and 2-story additions with a second-floor deck, which will replace the existing rear 1-story addition. With this application, I have material submitted by the applicant, 4 form letters in support. Mr. D'Oliveira.
Good afternoon, committee. My name is Mike D'Oliveira. I'm here representing 307 Willow Avenue, and I'm with Replacement Design, located at 911 Davenport Road.
Mr. D'Oliveira, could you just speak a little closer to the microphone? We heard you, but it was tough.
No problem. I'll try and speak a little louder here for you. Just have a bit of a hoarse voice myself.
Yeah. Now that I've asked you to speak louder, we don't need a presentation, so we probably don't need to hear from you anymore. But so this is straightforward. Do you have anything you want to say to the panel before we go into committee?
As you mentioned, we have the 4 letters of support, most importantly from the attached neighbor at 309 Willow. Our clients have also had extensive discussions with the neighbor at 305. However, we weren't able to get a letter back from them before the hearing, but they are aware of the project and they haven't raised any concerns. We are also well in line with other approvals on the street. We're only asking for a 0.1 FSI above the existing condition, and we're in line with other approvals on the street, such as 209, 207, 281, 172, who are all approved for 0.9 and above. So we're well within what's been seen in the neighborhood. And our eave setback is actually in line with the existing eave setback. We're just continuing the same condition with the addition moving towards the back. Open any questions you might have.
Okay. Questions, comments, or do we? Yes, here. Here you're on.
Sorry about that, Chair. I've got construction going on and I'm trying to avoid too much noise. The balcony on the second floor, is there an issue with any overlook by any chance? I mean, it's a very small balcony. It and it's set back, so it doesn't appear to be an issue.
No, there doesn't appear to be any concerns from the neighbor. Again, the balcony is more towards 309, which is the one we do have the letter of support on file for. So they haven't raised any issues with that balcony to us, and as far as we know, they're happy with the application moving forward as proposed. So,
Okay, thank you.
All right, any comments or a motion? Yes, Yim.
I can make a motion. I have no problem with this application, and actually the one-story addition does not extend further from the two next door houses anyway. So I will move for approval with no conditions.
We have a seconder, Zahir. All in favor? Your approval. Thank you, sir.
thank you very much. Have a good day.
Okay. Okay, item number 32, 8 GRASSI Street. The purpose of this application is to construct a 6-story mixed-use building, including 1 commercial unit on the ground floor and 15 residential units with a mix of bedroom types from front, 2nd to 6th story, balconies, a rooftop amenity space with an access, and a mechanical penthouse. This application is associated with site plan application number 1798888 STE 30 SA that is under review. And with this application, we have material submitted by the applicant. We have correspondence from Capital Projects Group, from City Planning, reports from Urban Forestry and City Planning, a letter from the counselor, support from 163 GRASSI and 11 Bolton, 26 form letters from properties on Queen Street and Booth Street, Booth Avenue, 110 Carolyn Avenue, and Bolton and Pape and McGee and Trolley, Crescent and Oak Street and Salter Street and Ewood Avenue and Chatham Avenue. 33 more letters in support and opposition from the GRASSI and Bolton's and Wardle Streets. Okay. Now, Mr. Dwar.
Mike, you've been unmuted.
Good afternoon. I believe there's a deferral request in front of the committee.
Can we have your name and your address, please, first?
Sure. It'll actually be Daniel Angelucci who is speaking to the deferral request. I'm speaking to the application. Should it come to that.
Okay. This apparently there was a mistake made in the notice.
Good afternoon, Chair and Committee.
What? So, this is the Dwar?
My name is Daniel Angelucci. I'm a lawyer at McCarthy Tatro. I represent the applicant Percy Ellis. Perhaps this is not in your record, Chair, but there is a committee staff recommendation to defer the hearing of this application today. My intent is to speak toward that and to put forward our client's position that this application not be deferred. And then subsequently, my client's urban planning consultant, Mike Dror, will speak to the merits of the application. I've been advised by the Secretary Treasurer that we will both be given 5 minutes to speak. If that's not the case, please advise otherwise.
Who did you say was going to be given 5 minutes?
Myself to speak towards city committee staff's deferral request, and then
Well, we're only going to deal with the deferral request initially.
that's great. And in that case, Chair, I will speak towards the deferral request.
Okay. All right, go ahead.
Thank you, Mr. Chair. Again, my name is Daniel Angelucci. I'm a lawyer at McCarthy Tatro. I represent the applicant Percy Ellis. Before I begin, I want to thank Ms. Salatino and Ms. Ivanov, the two Secretary Treasurers, as well as Sarah Fatahi, the files application technician, for their assistance to date on this matter. Chair and committee, you have a recommendation in front of you today that this application be deferred. On behalf of the applicant, I want to advise the committee that we do not consent to a deferral. As a general overview of where we are at today, my client applied for minor variances for the subject property in December 2022. For that application, my client sought a zoning certificate from Toronto Building, which was issued on November 15th, 2022. Following our own internal due diligence, we identified that the parking standard variance identified in that zoning certificate was incorrect. My client then reached out to building staff, advised them of this error, and staff issued a revised and correct zoning notice dated March 13th, 2023. There was only one difference between those two notices. The November 2022 notice states that 8 resident and 1 visitor parking spaces are required, whereas the new March 2023 notice states that 0 resident and 2 visitor parking spaces are required. While committee staff has identified that the parking standards come from different provisions of Bylaw 569/2013, both variances identified relate to the total amount of parking required on site. Again, the old notice stated that a total of 9 parking spaces was required and 1 was being proposed, whereas the new notice states that a total of 2 parking spaces are required and 1 is being proposed. In each instance, the overall impact on the ground is unchanged. Our client has always intended on providing 1 visitor parking space. Our client has always required a variance relating to the parking standards in Bylaw 569/2013, and the bylaw required to be varied has always been Bylaw 569/2013. It is because of this change that committee staff is of the opinion that revised public notice is required and that therefore the hearing of this application today be deferred. The committee has the power under the Planning Act to not require new notice for a revised application where, in the opinion of the committee, the amendment to the original application is minor. I think it's trite to say that the committee may amend the variances at a public meeting where the variances being sought are reduced and not increased. In fact, there are multiple instances in today's session where the committee agreed to remove or reduce variance standards associated with multiple provisions of Bylaw 569/2013. As such, in our submission, we respectfully request that the committee use its powers under the Planning Act to not require a revised notice given the circumstances. We wish to submit that the public notice associated with the old zoning certificate was circulated by the committee in compliance with the rules, and that the notice of this application was posted on site. There's no dispute about that. I would also submit, given the record in front of you today, that there is sufficient evidence that the community is more than aware of my client's application. You'll note in your committee package that there are numerous letters of support and opposition that you have received, including a letter from the ward councillor. We submit that circulating revised notice is redundant, given the vast evidence of the community's knowledge and involvement in this application. And in our opinion, requiring revised notice and deferring the hearing of this application today would not be a beneficial or judicious use of the committee's resources, the community's time, and my client's time. We also submit that under the test of the Planning Act, the amendment to the variance is minor, given the fact that our client has always intended on providing 1 parking space, the fact that our client has always required a variance relating to parking standards in Bylaw 569/2013, and given the fact that the bylaw required to be varied has always been Bylaw 569/2013. The difference between the old notice and the new notice is immaterial in our opinion. In our respectful submission, it is of no important consequence that the provision identified as requiring a variance is different from the November 2022 notice to the March 2023 notice. We therefore request that you exercise your powers of committee under the Planning Act, not defer the hearing of this application, and proceed to hear the statements of my client's urban planning consultant, Mike Dror, as well as the statements of the surrounding community on the merits of the application as they relate to the 4 tests under the Planning Act. I'm available for any questions the chair committee may have. Thank you very much for your time.
Right, so could you tell me what the staff has suggested that the notice needs to read with respect to parking spaces in order to be acceptable?
Sorry about that, Mr. Chair. I appear to have been muted briefly there for a second. The correct variance is noted in front of you as variance number 1 there. Or sorry, that's the incorrect one. If I could ask staff to go to the March 2023 notice, zoning certificate notice that is filed in the AIC as revised zoning certificate.
Well, while they're looking for that, could I just ask the question of the applicant?
Yeah, okay. I don't
just-
see this here. I don't see the revised one. Oh, just a minute. Is that at the very end? Oh, there it is.
So through you, Mr. Chair, this is the March 2023 zoning notice. That item number 9, identified as number 9, is the correct revised parking standard to be varied. You'll see that it says 2 visitor parking spaces are required, proposed as 1. The November 2022 zoning certificate, which should also be in your committee materials, will state that, and it's under item number 7, that a total of 9 parking spaces is required. So between the 2 notices, the parking rate is being reduced. The overall amount of parking required by the bylaw is being reduced, and the same number of parking spaces is being provided.
Through the chair, the required number of visitor parking spaces has increased in the new revised notice that has been submitted, as well as the bylaw section and bylaw number has changed, increasing the deficiency of the proposal.
Through you, Chair, while it's true that the number
I haven't found it yet. I got something that says zoning notice updated, but I don't see anything about parking in it. Is it the last document?
Through you, Chair, item 1 on the screen in front of you here is the variance as was included in the notice circulated to the community.
Yeah, I understand that. I've got that, but I don't have the.
Mr. Chairman, could I clarify with the Deputy Secretary Treasurer, because I think her point's an important one. In her opinion, the deficiency in the most recent notice, the deficiency appears greater. Is that correct?
Through the chair, that is correct. The deficiency is greater. The requirement has increased from the original notice. New notice would be required.
Thank you.
Through the chair, I would like to respond if I'm able.
Just let us find this. I see that there's a lot more to this document than I. So you say number 9, the proposed building. Identified. Consider parking accessible. Doesn't make. So are the eight units still require 8 parking spaces? That other unit 0.5 per dwelling unit. So you're required 7.5 plus 2 visitor parking.
Through you, Chair, I believe that is the correct that's the correct variance identified in the old notice, but that is not the variance that is in front of you right now as part of the new zoning certificate that was provided by Toronto Building. The new variance standard provided by Toronto Building is item 7, or sorry, is item 9 in front of you here, where it says a total of 2 visitor parking spaces are required.
It says plus 0.5 per dwelling unit.
Through you, Mr. Chair, I believe that is rounded down in this instance. With the number of dwelling units, that would be rounded down from 2.0 plus 0.05 down to 2 total.
Can I ask a question? In that case, can I ask the applicant, what you're trying to say is that according to variance number 9, there's not an increase in deficiency, right? As stated by this Deputy Secretary. It's actually not an increase in deficiency. You still provide the same amount, I know, but is there an increase in deficiency?
Through the chair, so if previously 1 visitor parking space was required and now if 2 visitor spaces required, so the requirement in essence creates a greater deficiency for the proposal on the site.
Well, there was no deficiency before with respect to visitor accessible parking, because it was said there was only, and they were providing one, right?
Yes, I believe so.
So now it shows a deficiency of 1, 2.
Through you, Mr. Chair, I'm not certain if the staff who has control of a screen right now has the old zoning notice available, but for comparison, I think it's helpful if they go to the agenda for this item. They previously had it on screen before, and hopefully I can shed some light here on the distinction, because I believe it's important. So this is the requested variances based on the old zoning certificate provided by Toronto Building. You'll see item number 1 here on this list identifies a variance required to chapter 900 of bylaw 569/2013. That standard, based on a misinterpretation of bylaw 569/2013, required the applicant to receive a variance to reduce the parking spaces for residents from 8 to 0 and 1 to 1 in that case for visitors. So a total of 9 in that instance was required. This was the error that we flagged for you and that we flagged for Toronto Building, and a revised notice was then required. So under chapter 900, a total of 9 was required, inclusive of 8 residents and 1 visitor. In this case, in communication with Toronto Building staff, we've identified that this provision does not apply to our site. What does apply, and I'll ask the staff member with access to the screen to go to the revised zoning notice. Thanks very much. And that one there is item number 7. You'll see here that the provision being varied is not Chapter 900. The provision being varied is 200-510-1. 200-510-1 of 569-2013 does not require resident parking. It requires visitor parking. And in this instance, based on the new standard in 200-510-1, we're going from 0 resident required to 0 being provided, and 2 visitor required to 1 provided. While it's a deficiency in the terms of 2 visitor required to 1 visitor required, overall the parking on the site is going from a requirement of 9 spaces to 2. And in both instances, my client is proposing 1. We submit that it's a technical amendment. This is obviously minor. And in our opinion, it does not require new notice to the community based on the test in the Planning Act. In our opinion, this is a minor amendment to the application, and this application should be heard today.
The issue is whether the notice that went out misleading or so that something
Through you,
we can overlook.
Through you, Mr. Chair, it certainly wasn't the intent to have a misleading notice. And in either event, both notices identify that only 1 visitor parking space is being provided. I would submit that this is minor. There's multiple cases this afternoon where the variance being proposed and the standard being proposed has been reduced without being deferred by the city, by the committee. And I submit that this is also an appropriate instance in where this is done.
Through the chair, in this case, the requirement has increased, and the requirement is different from the original notice that went out to the public. The requirement has increased in this case, and it is under a different section and a different bylaw. We would be unable to amend those sections and that number on the floor of the hearing.
Through you, Mr. Chair, I just like to note that it is not a new bylaw. Bylaw 569-2013 has been amended by Bylaw 89-2022. That was the city's citywide bylaw reducing parking standards across the city. That bylaw amended 569-2013. We are not seeking an amendment to Bylaw 89-2022. We are seeking an amendment to Bylaw 569 as amended by Bylaw 89-2022. It is not a new bylaw in our submission.
Through the chair, it is a different bylaw that was quoted on the original zoning review in the public hearing notice that went out. The number is different. It does not reflect the same number. So while it may be an amendment, it was not reflected in the original public hearing notice.
Yeah, but I think it's correct in that we've got to consider, the committee's got to consider whether it's misleading or whether it's mislead any.
Mr. Chairman, can I add a comment? I think that we also should look at into, this is, if
Different section, just a minute.
Yes, it's a different bylaws, and also if it's
Just
not.
a minute, Jim.
Oh,
Just a
I'm
minute.
sorry, I didn't hear you. I thought that I'm allowed to speak, sorry. Okay.
Okay, so and the law is, and I've seen it in the reports at the Ontario T-Lab, et cetera, that if the notice is not misleading, then and considered minor, it can be considered by the committee and the committee decides whether it's acceptable or not. I know Sabrina has in the past told me that if it's not correct, it's out, but I think she's wrong because I've seen the cases. Okay, Yim, what's your comment?
My comment is also, we have to consider what is the benefit of deferring it. It seems that, as you say, that we should also give a chance to say that whether it makes any difference to the public. with this technical maybe mistake or overlook. I do not see there's any benefits to delay it. I agree with the applicants that we should consider we can put a vote, we can put it into a vote whether we should defer it.
Okay, but first we've got to consult with the opponents. So I don't want to go to each opponent. I want to ask you if you are prepared to proceed or you want a deferral at this point. So how do I get, Stanley, how do I get these people to tell me yes or no? Yeah. Yeah. Oh, we can't do that, right? Yeah? Yeah.
Not happy now. Just say, give me. Okay, just,
Hello, can you hear me?
Yes.
oh, there you go.
My name is Motaz Nofal. I live at 12 DeGrassi, the property right next to 8 DeGrassi Street. We actually
Okay.
have, we would like to continue with the deferral, and the reason being is at the beginning of this committee meeting, multiple of the objectors were all notified at the beginning of this call that there was going to be a deferral, and we've actually lost numerous community members that were going to speak, and they've all disconnected based on that premise.
So you want a deferral?
Yes, please. We would like to continue on with a deferral, given that we've lost numerous members of the community that were going to speak.
Okay. All right, so we'll go into committee and discuss it. So do you have any comments, Carl?
Thank you, Mr. Chairman. I agree with Yim that it would have been preferable to proceed today, if possible, because this is going to be a very long debate and there's a lot of concern. I am reluctant to go against the recommendation of the Secretary Treasurer, so that would cause me to favor a deferral. But most importantly, the adjacent owner's comment just now, I think we have to take very seriously. If in fact a lot of people that were going to participate are no longer connected because they thought that this was deferred or going to be deferred, then, and they don't have another opportunity to comment because of the recent changes to the Planning Act, I would be very, very concerned with that. So for a variety of reasons, I would support a deferral.
Is here?
A variety of reasons, I would support a deferral.
Okay, Zahir. You're muted, Zahir.
Thank you, Chair. I'd just like to echo Carl's comments, and I prefer to go for a deferral.
Okay, Nimrod.
I would agree with those comments. I would support a deferral.
Okay. Yim.
Yes, I was not going to support deferral because I agree with the applicant's reason, but given now most of the oppositions are not connected, I do not think it's fair not to give them a chance. So I will support deferral for that reason.
Okay, I agree with you, Yim. All right, all in, so first we need a motion. Carl, would you make a motion?
Yes, Mr. Chairman, I move that the application be deferred.
All right, seconder, Zahir. All in favor of deferral? All right, matter is deferred. Okay, where are we? All right, so now we have to Okay, next item is 534 Perth Avenue. The purpose of the application is to alter the existing two-story detached dwelling by constructing a two-story north side and rear addition, a complete third-story addition with a walkout rooftop deck, a covered front porch with a walkout basement, a front second-floor balcony, and a rear ground-level covered deck. With this application, we have material submitted by the applicant and two form letters in support. Marco Vieira.
Good afternoon, Mr. Chair. Marco Vieira here, 257 Dunraven Drive, and I am the agent for this application. And we actually have to request a deferral because of an error made to the zoning review in which one of the variances associated with FSI was missed.
Okay, there's no opposition, so take it into committee. Do we have a motion for deferral? Yes, Nimrod.
Yeah, I would move a motion to defer this application.
All right, seconder, Carl, all in favor of deferral? Have your deferral. Thank you, sir. Number 157 Coxwell Avenue, that's number 34. The purpose of the application is to alter the existing three-story detached dwelling by constructing a basement addition, also to install a front yard parking pad. With this application, we have material submitted by the applicant and correspondence and concern from 153 Coxwell Avenue. Michael Cogan.
Present. Can you hear me?
Michael, you may want to speak a little bit louder.
Okay. Can you hear me now?
Yes.
Okay. I think the variances are incredibly minor.
Can we have your name and address, please?
Michael Cogan, and I'm at 40 St. Clair East, Suite 303.
Okay. I think the variances are minor, and we're going to take into committee. We don't need a presentation. Is there anything you want to say to the panel before we go into committee?
There was a letter from the neighbor with concern about the right-of-way, and we're not impeding on it or building in it. So I just want to make that clear.
Actually, I have a quick question.
Go ahead. Jim?
I just I cannot find the parking pad on your site plan. I do not know where it is.
If
Into the building.
You can't see it. It's under the front porch.
Oh, okay. Like maybe that's why I was looking, I couldn't find it. Okay.
Yeah, and the only reason they don't, I don't think a dwelling unit needs parking anymore. But if we didn't go to committee for this, I'm worried the curb cut might disappear one day.
Oh, okay.
So that was the purpose of going to committee.
Okay. All right. Any further questions or comments, Carl?
Thank you, Mr. Chairman. Could I just clarify that there is no landscape provision in the front yard? It's very unusual that there isn't. I just wanted to make sure that you didn't miss it.
No, the driveway is existing, and then you're under the building. You're beyond the main wall. And this is all this. I mean, we're only doing a basement. It's not even a basement because it's not below grade per se. It counts in FSI. So we're not touching the driveway that's already there. It goes down. I'm not sure if you're familiar with this.
I appreciate all that. There's normally a bylaw requirement for a percentage of soft landscaping in the front yard. There is no such provision on this site?
I don't think so, because this house was built like in the 90s or something. So all this stuff was dealt with years and years ago. We're only building under the existing footprint.
Yeah. No, I appreciate that. Okay, thanks.
Okay, Nimrod?
So if there are no other questions, then I'm prepared to put forward a motion. I think there's only two variances, and I believe they are minor, and I would move approval with no conditions.
All right, seconder, Yim, you seconded. All in favor? Have your approval. Thank you, sir.
Thank you.
Number 35, 396 Summerhill Avenue. Right, the purpose of this application is to convert the existing three-story semi-detached dwelling into a two-story mixed-use building by constructing a complete fourth-story addition, a basement, and four-story side west addition, and a first-story front platform with stairs. The altered building will accommodate retail uses in the basement and ground levels, personal services on the second and third levels, and one residential dwelling unit on the fourth level. With this application, we have material submitted by the applicant, and we have opposition from 394 Summerhill Avenue. Tony Valentin.
Tony Valentin, you've been unmuted. You can speak now.
Hello?
You may want to speak a little closer to the microphone.
Hello?
Mr. Valentin, we can hear you, but very faintly. Perhaps you could speak up.
Well, actually, the one who will do the presentation now is the owner himself, Mr. Navid Tagali.
Okay, but we need you to speak into the microphone because we heard you, then you faded out.
Well, I'm already speaking to the microphone, but I don't know why.
Well,
I am here.
Okay.
Members of the committee, can you hear Mr. Tajali,
Well,
the owner?
One moment.
Hello?
just hang on.
Navid, you've been unmuted.
Good afternoon.
I can hear you.
Okay, we can hear you a little better. So just give us your name.
Good afternoon, Mr. Chair and members of committee. My name is Navid Tajali.
Okay, and you're the owner?
I am the owner and I am the project manager. I'm partner in this project and I am the project manager as well. I did hear that there was some objection to coming from 94 Summerhill. We weren't notified of that, but again, I'm here to answer any questions.
Well, it's in the file, but it's not,
No
but
worries.
that person is not online, so we're going to deal with the application, the variances as they're put forward. So they look fairly straightforward. I'm going to take it into committee. Do you want to say anything to the panel before we go into committee?
Sure. So again, we are keeping in line with the existing structures, the commercial residential structures that are on Summerhill. Again, it's very straightforward. As you mentioned, we're adding a fourth floor. We're increasing the GFA, and the permitted encroachments, number 8, 9, 10, 11, we are actually in talks with Mr. Jivathan Rajvinderdam, who is the engineer technician of the permits and enforcements. So we've been in communication. We've also been in contact with Mr. Hector Alonso, and I believe it was Mr. Nathan and Mrs. Sipo from Assistant Planner and Community Planning. And we work with them and have some edits on the location of the front stairwell. And I guess that's pretty much it, yeah.
Okay, thank you. Panel, do you have any questions or comments or emotion? Carl?
Thank you, Mr. Chairman. In the opposition letter, there were concerns that there was a wall that you were extending and your building was in fact going to
Carl,
block.
speak up, Carl.
Can you hear me now?
Yeah.
Yes, I can hear you.
Your addition was going to block property 394, and the wall you were putting up was going to create a problem as well. I couldn't understand that objection because from my information, immediately next to you is a parking area. It's an open space, and then the building starts. Can you shed any light on what that concern was? And I didn't know if the revisions that you made that we got late last night, you made some revisions, whether
Yes.
any of those were in response to that opposition.
So Carl, you are correct. Immediately towards the west side, it is a parking pad. So the only thing that I can think about is in the drawings, if your staff can go to it, I believe it's the perspective drawing, the last one. It kind of shows a 3D image. This is what I'm thinking maybe the neighbor is suggesting, which I've actually spoken to, and he didn't bring this up to me. There is a sinterlock block. Do you see how it's coming out, blocking the, what should I call it, the staircase there? So I believe that could be his concern, but that won't be there. You will actually be able to see the staircase on both sides, the east and the west. So maybe he's speaking or she's speaking about that, but again, it is a parking pad, but that sinterlock block that's protruding out onto almost the sidewalk there, yeah, right where the cursor, could you put the cursor back there? Awesome, right there. So that won't be there. So hopefully that sheds some light, I guess. Yeah.
And the changes you made that came in late yesterday, are they in any way to address any of the concerns? Because I've just plain didn't understand the
No,
concern.
so yeah, no. So basically the changes, do you see the staircase on the east side beside the pole there?
Yeah.
That entrance, that stairway was actually in the middle blocking the two lower, yeah, that's right, was blocking the two lower units. And
Yeah.
when I spoke with the assistant planner, community planning, Mr. Hector Alonso, Mr. Nathan, and Ms. Sipo, we all came to an agreement. Exactly. It's all bubbled there. So we moved the staircase to the east side, and everybody seemed to be on the same page.
Okay, thanks very much.
Yes, Nimrod.
I've got a question. So is that 4-story addition going right to the side property line?
The 4-story addition, correct.
And so that my impression from reading the adjacent owner's letter was that I think the concern was that then he's going to have a 4-story building right at the lot line adjacent to his property with no setback from the side lot line.
That's what you, okay, so there is currently a 2-story that goes to that lot line right now. Again, to be honest, this whole street is zoned commercial residential. All of the lots, including 400, 402, 404, they're all, I guess, on the lot line and 3 to 4 stories. Yeah, so that's where we're looking right now. If you go to, that's where his car is. And to be fair, it's about 20, like it's a distance away. It's not, it's, I couldn't say, I would say 3 parking spaces. Again, it's not, but if you look at 400, 402, 404, you'll see them all stuck beside each other.
But his objection is that it blocks sunlight, but it's blocking sunlight from a driveway. That was what I didn't.
Yeah, from a driveway, yeah.
I believe Nimrod, you're right, that he is concerned with the wall there, but I didn't understand it. It seemed to me that the issue would be an issue if there was a garden there, but there isn't.
And just as a clarification, there is no side yard setback that's required. Is that correct?
That's correct.
Okay, thank you.
All right. Any comments or a motion? Yes, Nimrod?
You know, based on what I've seen along the street, I think what's being proposed is appropriate, and I believe the variances are minor in nature, and I would move approval with no conditions.
All right, do we have a seconder? Yim, all in favor? Sahir, are you in favor? Sahir? I think Sahir is, yes, he's in favor. Okay, thank
Yeah.
you. You have your approval, sir. Number 36, 151 Annette Street. Purpose of the application to alter the existing two-story building, West Toronto Masonic Temple, by constructing a barrier-free access ramp on the west side fronting Azeel Street. With this application, we have material submitted by the applicant, Mr. Zblinsky.
Andrew Szeplinski.
Hello?
Hello?
Yes.
My name is... Hello? Can you hear me?
Yes.
My name is Andrew Szeplinski. I'm an architect retained by Temple Board to design these alterations to the basement, and they are asking me for this handicap access ramp.
All right, can we have your address, sir?
My address is 75 Nantucket Drive, Richmond Hill.
Okay. I don't think we need a presentation. This seems pretty straightforward. Yeah. So, do you have anything you want to say to the panel before we go into committee?
It's very based on point 2 zoning notice. I'm crossing with this ramp the required setback in order to reach the city sidewalk.
Okay. Carl?
Thank you, Mr. Chair. Are we on committee?
Yes.
Thank
you
you,
can
Mr.
ask
Chairman.
questions.
This is a very straightforward and necessary application. It makes a property accessible for the handicapped. I'd like to move approval without condition.
All right. Say here, you second that motion. All in favor? Say here.
Yes.
He seconded, he must be in favor. Okay. Application's approved, sir. We got it. Say here. Okay. Number 37, 35 Old Mill Road. The purpose of this application is to alter the existing two-story detached dwelling by constructing a rear second-story addition and to enclose a front porch. The purpose of the application, the materials submitted with the application are materials submitted by the applicant and correspondence from Toronto Region Conservation Authority and Ravine Natural Feature Protection, and support from 23 Old Mill Drive. Salvatore Creamy.
Sal, you've been unmuted.
Good evening, Mr. Chair, committee members, and Committee of Adjustment. My name is Sal Creamy. Address is 2572 Eglinton Avenue West.
Okay, sir, thank you. This is very straightforward. I don't think we need a presentation. Panel, do you have any questions? Yim?
Yeah, I can put a motion for approval. The within natural feature protection has no condition and nothing. It's just asking for a small increase in area. So I will move for approval with no conditions.
I understood Yim, that Ravine had some conditions. At least I have
Sorry,
a
Mr.
note.
Chair, I didn't catch that. Can you repeat that?
Pardon?
I didn't catch. Did you have a question or concern?
I thought Ravine had some conditions.
No, I
Um,
reached out to them. I reached
the
out to them
beginning.
before. I reached out to them before it was circulated to them because I wanted to stay ahead of it. There was some confusion that there would be additional excavations beyond the existing foundation footprint of the building. I confirmed that no, we're working with the existing foundation, no excavations, and we clarified construction access and material laydown. After that clarification, they had no concerns with the application, and that material should be within your package.
Yes, Mr. Chair, the later report that say there's no condition. The two later reports
Okay,
say
that's
that they
fine.
do not have any concern.
All right, as long as we have the reports in the file. Okay, so you make a motion. All right, and Zahir, you second the motion, and all in
Yes.
favor? Have your approval, sir. Thank you.
Thank you.
Okay, so now we have to switch to the next segment. Okay, the next item is number 3876 Pinecrest Road. The purpose of the application is to alter the existing two-story detached dwelling by constructing a below-grade basement addition with a deck and staircase above, as well as an attached one-story garage for one parking space. With this application, we have materials submitted by the applicant, a report from Ravine and Natural Feature Protection, support from properties on Pinecrest, correspondence and concern and interest from Clendon Avenue, 3 letters of concern from Clendon Avenue. Okay, Agnes Skeen.
Angus, you've been unmuted. Angus, you've been unmuted.
Great. Hi, I'm Angus Skeen. I'm the architect and agent for this application. I apologize. For some reason, I'm having internet trouble today, so I'm phoning in and watching the hearing on a somewhat patchy internet connection, so I hope it doesn't get too tedious.
Okay, could you just give us your address?
Certainly. 142 Glendale Avenue, Toronto, M6R2T2.
Okay, could you give us a brief presentation, because there's someone
certainly
concerned about this for some reason.
No, yeah, for sure. This application was actually deferred from August 31st of last year. The proposal is this is a detached house where the rear yard is a sloping yard that comes under the jurisdiction of Ravine and Natural Features. It doesn't come under the jurisdiction of TRCA. So the proposal is actually an addition at the basement level of the house. But if you can imagine, since the ravine is sloping downwards, the basement emerges into the backyard. I'm hearing a little feedback. I hope you're not. So what happens is a basement addition in the backyard creates 3 zoning variances. And the variances have not changed since the deferral. But what happened was Ravines and Natural Features had some concerns about the proposal. And so I met with them after the deferral, and we came to an agreement, and the proposal was revised to their specifications. And that's why if you refer to the Ravine report from March 15th, you'll see there's no conditions, and an application for ravine clearance has already been made under an arborist's report. There's substantial support for the application on Pinecrest, and there's 2 letters of concern from down the hill on Clendenin. And I think if you go through those, you'll find that the nub of them is concern over the ravine, branches falling, or, that this project won't somehow. When you're at the bottom of a hill, I think it's understandable. People are concerned that something's going on up the hill. And The owner of this property, 76, wrote directly to both owners, and their letters are in the file, and essentially saying that by working through ravines, we've obtained and we are following all the regulations and all the processes that apply for this kind of construction, and hoping that that allays their concerns, and the usual sort of looking forward to good neighborly relations going forward. So I can explain a little bit about the variances if needed, but basically there's a depth variance, which is partially triggered from the front yard setback being taken from not the front of the house. It's one of these things when you average the front yard setback on a curving street, it's floating about 1.5 meters in front of the building's front wall. So that doesn't help them in terms of a depth variance. But nonetheless, there's a depth variance. There's a side yard setback variance for the attached garage. So that's on the south side of their property, on the lower portion on the page. And that's because the garage is actually reachable. While it's a detached garage at the ground level, you can walk into it at the basement level. And since it becomes part of a house, it can no longer take advantage of the zero setback that a garage enjoys. It has to comply with the setback for a house in the R zone, which is 0.45. So nonetheless, we've got a side yard setback from that garage. And then inside the garage, since it's somewhat smaller than the regulations require, there's an actual third variance for just simply having a slightly too small parking space inside the garage. So those would be the three variances. I can wrap it up at that and obviously answer any questions that the committee might have. And again, I apologize if it's a patchy connection, but it's my first phone call into this sort of thing, so I'll do what I can.
We had a good connection. Okay, any questions, panel? Yes, Carl?
Thank you, Mr. Chairman. Mr. Skeen, thank you very much for your generous comments about the people in opposition. It's very, very kind of you to put yourself into their shoes and understand their concerns. My question is a simple one. On the site plan that's on the screen right now, the deck faces basically the back amenity space of number 78. Do you feel, and yet there is a distance between the deck and the property line. Do you feel that screening is necessary on the north side of the deck?
Hold on. Just to confirm your question, we're talking about the rear deck, which is at the first floor level of the 76 Pinecrest. I thought you mentioned Yates. Is that correct, or did I misunderstand on the phone connection? Are you concerned with any overlook to number 78 Pinecrest, like the neighbor to the north? Is that the question?
Yes.
Oh, okay. I think these are substantial lots. I'm completely used to putting up privacy screens, on all kinds of decks, in the R zone, when the lots are smaller or it's a third floor addition or something. But if you're asking my honest opinion, I don't think it's suitable here. And there's a support letter from 78 Pinecrest as well. So I don't feel it's necessary. Obviously, in these kinds of applications, if the committee felt it was necessary, it's a small price to pay for an overall approval, but that's my opinion.
There's already been consultation between the two of you. I just wanted to get a sense of whether there is a concern, but there isn't. So that's fine. Thank you.
Okay.
All right, Suzanne Boothby.
Through you, Mr. Chair, we haven't been able to connect with Suzanne Boothby. She's been emailed and called a couple times. We do have Federico.
Okay, let's have Federico.
Federico, you've been unmuted.
Yeah, hi. I was going to connect later on. Sorry, thanks for calling me because I thought it started at 5:30. But yeah, no, I just wanted to say I was in support of the
Can we have your name and address, sir?
Federico Sanchez, and I'm at 84 Pinecrest Road.
Okay, so you're in favor of the project?
Yes, I am. Yeah, I took a look at the plans, the full plans, and I thought it made sense. I thought it was unobtrusive, and I just got on now, so I don't know what the people who are against were saying, but from the plans, I thought it looked like a great idea actually, and yeah, no, just wanted to say I was in support.
Okay, thank you very much. All right, Mr.
Thank you.
Mr. Skeen, we don't need to hear from you again. All right, panel, do we have any comments or do we have a motion?
Mr. Chairman, I'm afraid I can't hear you at all.
Must be something wrong with the mic.
I can hear everyone else, but I can't hear you.
Closer. Can you hear me now, Carl?
Yes, I can. Thank you very much.
Oh, Jesus. We need a microphone with some power. Okay, so do we have a motion? Yes, Nimrod.
Yeah, I'm happy to put forward a motion to approve the variances. I believe they are minor in nature, and I would move approval with no conditions.
Okay, seconder. Carl, all in favor? You have your approval, sir. Thank you.
Thank you.
Number 39, 241 Franklin Avenue. The purpose of the application is to convert the existing one-story ancillary building detached garage in the rear yard abutting the laneway into a laneway suite by constructing a second-story addition. With this application, we have material submitted by the applicant, correspondence from community planning, opposition from 230 Franklin Avenue, Mr. Benskowski.
Jonathan, you've been unmuted. Jonathan, you've been unmuted.
Yeah, good afternoon, Mr. Chair.
Good afternoon.
Jonathan Benskowski, 301 Keewatin Avenue.
Okay. You have some opposition, so we need a brief presentation.
Yeah, so this is a deferred application. We worked with planning. It originally had an overhang that extended. Hello? Are you able to hear me? Okay, sorry.
It would be helpful if you spoke a little louder.
I've never heard that before, Mr. Chair, but I'm happy. I'm happy to give that a go. This is a deferred application in light of some comments from planning relating to a second floor projection that went into the rear yard. It has since been revised to essentially be an exact top-up over the existing garage that's located there. There is no alterations to any of the setbacks between the dwelling and the main wall, as well as the rear wall and the laneway itself. Essentially, if this were not to move forward, this would essentially not be able to have a laneway suite, basically because of the existing house, which is remaining untouched, and that existing separation between the two. In terms of the height, I would just like to say it is only a 2.44 meter or 8 foot second floor to ceiling height. So it's not an egregious height that's pushing the building up. It is a modest 8 foot on the second floor. And again, just to reiterate that this is really just a top up on top of the existing garage. And that is illustrated on the side elevations, where you can see that the pitched roof is just being removed in light of a flat roof coming on to accommodate the proposed laneway suite. And that's my presentation. I'd be happy to answer any questions.
Nimrod?
Yeah, one of the letters from a neighbor indicated that there should be parking provided on site. Is there a zoning requirement for parking?
No, there is no zoning requirement for parking throughout the city for I think it is dwellings up to 4 units actually, in light of the new parking requirements. And this was done by way of a zoning review, not a zoning waiver also.
Thank you. And I had a question about the height. Under the zoning limit of 4 meter height, can you fit a 2-story unit
Through you, Mr. Chair, Mr. Solomon, absolutely not. That was what I was saying, where because of the existing separation that's there, it limits that height at 4 meters. So no, you would not be able to fit a laneway suite on this property utilizing the existing structure that's there.
Okay, thank you.
Okay, Matthew Sawa.
Matthew, you've been unmuted.
Hi, can you hear me?
Yes, we can.
Yes, hi. My name is Matthew Sawa, resident from 239 Franklin Avenue. Sorry, just to follow up, because I did have concerns. I was the one that wrote the letter as well in case I couldn't make the meeting. Can I just get some clarification on the parking? Because this property's been to Committee of Adjustments before. Is this you know, they were required to have resident parking for the tenants who are currently there. So I'm curious as to why you're adding more tenants to the property, that the initial condition of parking is not there. But if there's been a revision that I'm unaware of, that would be helpful to have some light shed on it.
Okay, anything else? We'll get Mr. Benskowski to comment on that.
Oh, yeah. I mean, like I said, I just have concerns in general. There's been no contact with the builder or the owners about any of this to address any concerns whatsoever. And I don't, you know, we've had issues with this builder in the past, so there's a long-standing issues of mistrust, to be honest, and it hasn't been a welcoming addition to the neighborhood. So I do have many concerns. I'm frustrated that there's been no communication, and I would like the suggestions or issues that I've pointed out in the letter to be addressed.
Okay, thank you. Mr. and Mrs. Beck Chiaris.
7 months. You may want to leave a message.
George and Vivian, you'd been unmuted.
Thirty seconds remaining.
Yeah.
Could you kindly leave me your name and number? I'll call you.
Okay, we'll just pass on. All right, Mr. Benskowski.
Yeah, to address the parking, chapter 200.5.10, which deals with the parking rates, says that the residential requirement for a dwelling unit in a detached, semi-detached house, townhouse, duplex, triplex, or fourplex, there are no parking requirements in all 4 of those categories, which is what this would fit in. In terms of the past violations, I can't really speak to those. I'm not really sure what those are. And yeah, I'd really be happy to answer any questions. Again, just to stress, this is a top-up of the existing garage that is there.
Okay, panel, do you have any questions? Yes, Carl?
Thank you, Mr. Chairman. In the planning department correspondence, they've indicated that they're now happy with the proposal because you've increased the distance between the ancillary building and the main house from 5.52 meters to 6.44 meters. If the house and the ancillary building are already there and it's just a top up, how did you increase the distance between the 2 buildings?
So through you, Mr. Chair, Mr. Knipfel, what we had was, it was a chicken and an egg. Did we want to comply with the 45-degree angular plane or not comply with the 45-degree angular plane? So the previous proposal had the wall between the dwelling and the garage, there was an overhang, which was the difference between that 5.52 and that 6.44. But that overhang included the 45-degree angular plane for compliance. So in speaking to planning, and again, it's really a half a dozen, one or the other, because you can't use a lot of that angular plane area anyways. So the preference of planning was to eliminate the overhang area, build it flush with the existing, which would be west wall of the garage, and go flat up. So although the previous proposal also was maintaining the footprint, it just had an overhang, bringing it closer to the dwelling.
Okay, that's clear. I was wondering if you had some magic way where you had wheels on buildings and you could move them around.
Well, Mr. Knipple, I've been told to be quiet today, so anything can happen in these hearings, I'm finding out.
The other point I'd like to just stress, the objectors had indicated that there's been no consultation with them on the project, and I would encourage you as you go forward to consult with them. It just makes matters so much easier if you can speak and collaboratively resolve problems.
Thank you, Mr. Knipple. I will note that.
All right, panel, any further questions, or we have comments or a motion? Yes, Yim?
I can move a motion. I think that with the revision, and I think it's like a little bit less than 7.5, about a meter deficiency. I think I can accept that, and that's not. It's pretty neat design, very compacted, and it's good to increase some housing stock here. And so I move for approval. I do not think that is there's any conditions though. No conditions. Yeah.
Seconders here, all in favor? You have your approval. Thank you.
Thank you, committee.
Number 40, 43 Regal Road. The purpose of the application to alter the existing one-story ancillary building, a detached garage, by constructing one- and two-story additions for a two-story laneway suite. With this application, we have material submitted by the applicant. We have a report from Urban Forestry. We have correspondence and opposition from properties on Regal Road. Right. Okay. Mr. Giacomini.
Yes, can you hear me?
Yes, we certainly can.
Okay, good afternoon, Chair and members of the committee. I'm Egidio Giacomini at 42 Industrial Street, Suite 131, Toronto, M4G1Y9, and I am the agent for Jim and Ann Hassel, the owners of 43 Regal Road. The proposal we submitted at the previous hearing of November 2022 was revised and totally redesigned to reflect the neighbors' concerns voiced at that hearing. A deferral was granted by the committee so that we could consult with the neighbors. Number one, height was a concern. At the last hearing, we lowered the height by approximately 2 feet from the original proposal presented on November 2022. Number two, views were a concern. So we directed the views towards the lane to respect both the adjacent neighbors' privacy. Number three, the existing east wall of the garage, which is decades old, built by the previous owners, encroaches on the neighbor to the east at 41 Regal Road by less than 1.25 inches for about 9 feet. We proposed to inset the wall further to the west after the neighbors at 41 Regal decided to revoke a signed encroachment agreement they had with Jim and Ann Hassel. The proposed new wall will not encroach on the neighbor's property. Number four, the proposed attached garage was reduced to a minimum. Number five, shadow studies and an arborist report were filed with your office. Number six, the 18-centimeter diameter serviceberry shrub dash tree was part of these, is not part of zoning. We intend to comply with urban forestry at time of permit as they have jurisdiction. Now I can go over the various variances. Number one, It is our intention to retain the existing front and back foundation walls and to slightly inset the new wall facing the lane. The rear lot line is angled. The southeast portion of the existing rear wall is set back 1.26 meters from the rear lot line, where 1 meter is required. Number 2, we plan to reuse the existing back foundation wall facing the lane. This is an existing condition. The relief we are seeking amounts to 3 5/8 of an inch, or 9.22 centimeters. Number 3, the distance of 4.97 meters refers to the cantilevered stairs window facing the residential building at the second floor. The cantilevered stair window is a design element to add some interest to the wall of the laneway suite facing the existing home. The distance from the existing two-story stucco addition built by the previous owners to the existing foundation wall of the laneway suite is 5.58 meters. The brick wall of the existing home, which is set back to the north from the front wall of the stucco addition, forms 46% of the rear elevation. The distance of south-facing brick wall of the home to the proposed laneway suite is set back approximately 9 meters. Number 4, the front main wall of the laneway suite penetrates a 45-degree angular plane. A portion of the second floor front wall at the southeast bedroom shown on page A6 is sloped back 1.56 meters, just over 5 feet, from the front north facing main wall of the proposed laneway suite. Number 5, the ground floor of the proposed suite is 7.82 meters. The second floor of the proposed suite has a width of 8.24 meters and exceeds the requirement by 0.24 meters. This refers to the width of the cantilevered second floor west-facing wall, which has been widened to accommodate a modest washroom. Number 6, we have proposed pictures of a laneway suite at 115 Yarmouth Road, Christie and DuPont, which is 3 stories in height. At 110 Yarmouth Road, at the hearing held on July 11th, 2019, the Committee of Adjustment approved an application for a laneway suite with a separation of 6.55 meters, a penetration of the angular plane, and a maximum building height of 7.25 meters. Their final and binding was granted on August 31st, 2019. Our proposed heights on both floors are based on 8 feet ceilings with minimum structure and a small parapet for water drainage. The ground floor is slab-on-grade construction, and our main entry located on the west side of the yard is approximately 4 inches up from grade. In our opinion, 5.93 meters is a modest height. Number 7, 2 bicycle parking spaces have been provided, referred to drawing A5 ground floor plan dated January 18, 2023. Thank you.
Mr. Giacomini, could you tell us what the use of this laneway suite is?
This is for a person that has special needs. She's middle-aged and she needs a place that's supervised. Her parents will help her out there with the house at 43 Regal Road, the existing house, and they'll help her out. Also, she also needs care, supervised care, and that's what we're proposing.
So she's going to have a caregiver?
Yes, she will have a caregiver at certain points of the day, but also her parents who are elderly will also help her out.
All right. So this is the parents building this residence for their daughter?
For their daughter, that's correct.
Right. Okay.
Question here.
Yep.
Yes.
And you said that you're providing 2 bike storage space.
That's
so,
correct.
Are you deleting variance number 7 then?
It's on, I can show you, it's on the, let me just see, it's on page A-05, and it's near the existing rear wood deck and stair of the existing home. There's 2 bicycle,
Yes, my question is, on our agenda, you still have a variance for bike
Yes, I know, and I
you're
forgot.
going to delete that?
I'm going to delete that, yes. Number 7 is deleted. Yes, thank you very much.
Yeah.
Yeah.
Okay.
Hi.
Okay.
Yes, Mr. Singh.
Mr. Chair, I have a question about the angular plane. I didn't see any drawings that showed how the angular planes affect the proposed building.
Are you talking to me, sir?
Yes, I am.
Yeah, there is an angular plane there. It's not 45 degrees, but it's on the second floor. And we took out a chunk of the second floor facing the house. That's for mechanical equipment, but it is angled. What we're trying to do is reduce the mass of it and just add some interest to the front elevation. That's all. But and also we didn't want any views. One of the concerns at the committee was that at the former committee hearing was that the former design looked into backyards, and we didn't want that. And if you look at our 3D, you could see that none of the main all the main spaces do not look into any of the rear yard. What they're doing is all the views are kept back and face the lane. So privacy is not an issue. That was something that we really wanted to do.
All right. Thank you.
Thank you.
Okay.
All right. Ted, Glenn?
Good afternoon.
Hello.
Good afternoon.
Yes.
Hello?
Yes, we can
My
hear
name
you.
is, my name is John Edward Glenn. I go by Ted. My wife Sarah and I live at 37 Regal Road. Thank you for the opportunity to speak today to the proposal. I'd like to use my time to reiterate 5 of the points that I made in our written position, and I also just want to address one of the points.
All right, sir, could you speak into the microphone because you keep fading out?
Certainly. Also speak to a point that the proponent had raised regarding the distance between the proposed suite and the back of the house. I'll address that first. I don't think you can pick and choose where exactly you draw a line from the back of the house to the laneway suite. The back of the house is the back of the house, regardless of whether you've got a addition that goes across half of it or not. 5.58 meters is the measurement that we're dealing with and that the bylaws refer to. My main point is that the city's laneway suite bylaws are clear. Owners of lots with shallow backyards can build single-story suites. Owners of lots with deep backyards get to build 2-story suites. The 7 requested variances aren't consistent with this intent. They're designed to facilitate development of a suite that, in terms of its mass, its height, its bulk, is appropriate for a deep backyard. Taken together, the requested variances are not minor, especially the variance to permit a height of 5.94 meters from the prescribed maximum of 4 meters. So the second point is would the granting of the variance result in a development that would be desirable for appropriate development or use of the applicant's land or building? Again, the bylaws on this are clear. Single-story suites, not 2-story suites, are desirable and appropriate for lots with shallow backyards. They're desirable and appropriate because they maintain positive relationships between adjacent structures, which the city's bylaws intend, and with respect to such matters as maintaining adequate privacy, sunshine, sky views. The photos I submitted, I hope, helped illustrate some of these points. Now, I think there might be room for additional consideration if there were something unique about the property to warrant some of the variance requests, topography, lot shape, orientation, but there isn't. It's simply a shallow lot with a shallow backyard, and the bylaws are clear that building a 2-story laneway suite on it is neither desirable nor appropriate. Bylaws also suggest that property owners on shallow lots are to choose between having a suite or having on-site parking because the mass, height, and bulk of a single-story suite cannot accommodate both. On this point, the proposed development is also not appropriate. We're also concerned that approval of these variances would set a dangerous precedent for similar requests in the future, as there are several lots with shallow backyards that abut Edward McElwain Lane, as it's formally called. And on this point, the proposed development is also not desirable. Number 3, does the variances maintain the general intent and purpose of the zoning bylaw? Again, the general intent and purpose of the bylaws are clear. Single-story suites can be built on lots with shallow backyards. 2-story suites can be built on lots with deep backyards. Period. The requested variances are for a structure that is appropriate for a lot with a deep backyard and are thus inconsistent with general intent and purpose of the bylaws. I think it's worth noting in this connection the Beaches East York pilot missing middle demonstration project that's currently underway that allows two-story laneway suites on properties with shallow backyards. I think it would be premature at this point to approve the requested variances until the results of the policy have been released and the cities assess the potential impacts. Number 4 is are the variances, do they maintain the general intent and purpose of the official plan? The official plan says where it can be demonstrated that it will respect and reinforce the existing physical character of the neighborhood and have regard for matters such as ensuring compatible height, massing, and scale, maintaining adequate privacy, sunlight, and sky views, laneway suites can be built. As I've said, the variances would produce a suite that is inconsistent with the height, massing, and scale requirements of a lot with a shallow backyard. Proposed height in particular would result in a structure that's insensitive to the privacy of neighbors and does not maintain adequate sunlight and sky views on adjacent properties. Last point I want to make today is about consultation. On November 2nd, the committee deferred the initial application so that consultation with neighbors could occur. The committee instructed the motion is to defer the application to give the applicant a chance to address concerns that the neighbors have and to meet with the neighbors and get back on the first available agenda when he's made revisions, end quote. On January 22nd, the agent submitted a revised proposal without consulting neighbors. The Hassel subsequently invited us to discuss the revised proposal on February 22nd, but no effort's been made to address our concerns, particularly around the proposed height of the suite, or consider alternatives like giving up the parking spot in order to achieve the desired living space, or dismantling the addition that's there to give the proper distance between the house and the proposed suite. We're disappointed, we're dissatisfied with the efforts made to consult with us on this important request. Thank you for your time.
All right, thank you. Linda Lemberg.
Linda, you've been unmuted.
East of 43 Regal.
Linda, you've been unmuted. You can speak now.
Oh, okay, I'll repeat what I just said then. Can you hear me now?
All right.
Yes. We could have heard you, but we can't hear you now.
How's that?
That's good. Let us have your name.
I'm sorry.
Let us have your name and your address, please.
Okay, my name is Linda Lemberg. My spouse, Jeffrey Rustlin, and I live at 41 Regal Road, the adjacent house to the east of 43 Regal. And we have a visual presentation, which we'd like you to show. And unfortunately, all the written submissions I've made have been packaged together. So this is the order of the visuals I'd like you to show, please. 1, the rendered perspective study created by architect Dominique Chang. 2, his shadow impact study. 3, my photo documentation. And 4, the alternate architectural plan designed by Harry Lay. Those are the 4 visuals. And unfortunately, you've got 27 pages of correspondences to go past Mr. Chang's 2 studies. So I apologize for that. So are you clear on what I'd like shown?
Through the chair, can you please also clarify what date you submitted that on?
The package was submitted last week, but Sarah Fatahi downloaded them on your site on the 21st. So March 21st will be the very last at the end of all the submissions. So I sent them for the committee. I'd asked for an extension because I was really sick. And so the committee received them, I believe, on the 17th. And then Sarah Fatahi on Monday downloaded them. And she said it should be there.
I'm wondering if this is in our supplementary package.
I think it's in the original, Nimrod. I've actually seen the presentation by the architect that you just mentioned. I'm just trying to find it. It's in our package of stuff because I've been through it.
Right, but there's two architects I've worked with. One did the render.
Mr. Lay that I was referring to.
Yes,
Sorry.
yes, that's correct, but that's at the very end of my presentation. The beginning of the presentation, the visual material should be two studies by Mr. Dominic Chang. One is the rendered perspective study created by him, and two is his shadow impact study. And it was all submitted. Sarah Fatah, he said it was, and I've seen it on the supplementary, the supported material site, and it appears on March 21st.
So
20 or maybe 20th.
I think it might be then on the supplementary agenda, correspondence in opposition to number
Yes,
2.
let's see. Do you want to see if that's it before I start? Is that okay?
Mr. Lay's material is under opposition 3.
No, that's oh, wait a second. Yes, render perspectives. Good. So unfortunately, so you can show those two first while I'm speaking, and then there's 27 pages of correspondences. We can just whiz through, please, because I don't want those shown. And then you'll get to my photo documentation and Harry Lay's alternate architectural plan.
John.
It's a lot of stuff. How does that sound?
Okay, well, it sounds fine, but you got 4 minutes left. So you better
No,
whiz.
this wasn't, sorry, I was told.
Go.
Okay, we along with Nick Giorgio and Linda DiGiorgio of 33 Regal object to requested variances 1, 2, 3, 4, 5, and 6 to build a 2-story laneway house with a garage. The proposed height of 5.9 meters when the law permits 4 is not minor, it's major. Mr. Ching's render perspective study illustrates that the height combined with its proposed mass would make the structure an imposing presence over us, our neighbors, and the laneway itself. It sets a dangerous precedent for overbuilding on the Edward McElwain Lane. We fully support laneway suites, which alleviate the dire housing shortage, and our neighbor's daughter deserves safe, independent housing, but this proposal would negatively impact our quality of life. Jeffrey has battled cancer for 2 decades. I've been chronically ill for 14 years and spend most of my time at home. The towering structure would overwhelm us, diminishing the enjoyment of our property. Mr. Chang's shadow study contextualizes the impact of the shadowing, including a date for each of the 4 seasons, and provides data for the afternoon when the building would be cast in shadow. Based on calculations from Canada West Weather Stats, we would lose more than 30% of the light we now enjoy. The loss of light inside our south-facing rooms would be detrimental to our mental health. As immunocompromised seniors, we do not have visitors inside the home because of the ongoing pandemic. Our backyard is our private social space, even in winter. The lost light would make it too uncomfortable for afternoon visits when the weather cools, and this would further isolate us. Our backyard is our sanctuary. The plants on the eastern half of it and southern bed would fail to thrive with deep shade. The number of pollinators our garden attracts would dramatically decline. Photographing them is my meditation. Tending the garden imbues us with purpose and meaning in all sorts of ways. It brings us much joy, and we get to share that joy with other people, including the children that come to it. We appreciate the revised plan mitigates encroachment of privacy. However, you can see from the back, there would be a direct diagonal view into our yard and south-facing views. It would be intrusive. The proposed structure would dominate our atypical laneway, which is it's not typical. Most are characterized by repetitive garage facades. The sloped terrain of ours had varied structures and open spaces. If the plan passes, it paves the way for 2-story infills. This would transform the laneway from being a bright, airy space with a diversity of structures to an enclosed shadow one with a uniform architectural profile. We need intensification, but development should be sensitive to the neighbors and community. Our laneway has ample spaces that will be suitable for 1-story suites. There's a bus right at the end of it and one around the corner. 1-story suites could replace garages. Some could accommodate parking pads. The laneway construction at 1254 Davenport, which backs onto the south end, inspired us to hire Harry Lay to devise an alternate plan, which provides the same square footage as the original, but eliminates the height variance. Even though this committee deferred so the applicants would meet with us to address our concerns, I took the first step with the hope of finding a possible design solution. I sent it to the Hassels on November the 25th. I asked Sean Galbraith, the urban planner for 1254 Davenport, what he thought of Harry Lay's plan. He said, I think it's a clever design. There are no quirks of geography to necessitate the variances like he had with his project. He suggested I hire Harry to draw interior plans to show the neighbors, and I did that. On March 6th, our first time I heard about the views on the plan, our neighbor's son wrote me that the concept was unsuitable for his sister. Throughout, there has been no meaningful effort to consult with us, as was instructed. We hope that our neighbors at 43 Regal find a design solution to accommodate their daughter's needs in better balance with ours and the community's, in which case we'd be happy to waive the encroachment of our east garage wall so that they can build using it. Thank you very much for the opportunity to voice our objections.
All right, thank you.
Sorry, I sped through that. I tried to do it in 4 minutes instead of 5.
All right, Lisa Grislis.
Lisa, you've been unmuted.
Hello, can you hear me?
Yes, we can.
Great. Thanks for your time. I know it's getting late. My name is Elizabeth Grislis. I go by Lisa, and I live at 39 Regal Road, which is 2 doors down from number 43. And I'm speaking on behalf of myself and my husband, Brian Mason. We really appreciate you taking the time to hear our voices. And much of what I'm going to say will echo what Ted and Linda have said really eloquently already.
Ms. Grislis, could you confine your remarks to comments that have not been made yet?
I think the comments that have not been made are just the direct impacts on our particular dwelling. We're 2 doors east of number 43, and our property will be impacted by loss of sunlight to our back deck and to our sunroom. And it looks like with the shadow study that Linda has uploaded, that there will also be effects further back in our backyard, which I did not submit photos of. I didn't realize that at the time. Otherwise, what I object to are similar objections. They are around the height, the general intent and purpose of the zoning bylaw, and the general intent and purpose of the official plan. I believe that a one-story laneway house would be suitable, but a 2-story laneway house is not. And I'm concerned about the precedent that it would set. And for that reason, I would ask that the committee maintain that the build should be held to the maximum permitted height of 4 meters.
Yes, Nimrod?
Yeah, I have a question. Are there any laneway suites along this part of the lane?
There are no laneway suites.
Okay. Thank you, Ms. Grislis. Mick Hassel?
Mick, you've been unmuted.
Thank you very much. It's Mick Hassel at 111 Greensides Avenue. You're more than welcome to start my video if you wish.
That's, you do that.
Okay, any suggestions on how to start the video? That's okay. I'll just, oh, here we go.
I believe if you right click, it'll show a little drop down menu that has an option to start the video.
Great. Found it. Thank you very much. So I am speaking in support of the laneway suite. And today I'm speaking on behalf of the intended tenant. The tenant would be the applicant's daughter, who is my sister. By way of introduction, we're all aware that there's a housing shortage in Toronto, and Toronto's official plan supports housing for people with disabilities. That's very important to my sister because she does have special needs. A laneway suite would be life-changing for my sister. It would mean that she can live close to her parents and get additional supports from them. And it would be a terrific living situation for her. Not only that, the laneway suite will improve the laneway. It's a fairly rundown laneway, and this new build will not only create new housing, but bring some revitalization to the laneway as a whole. In terms of the Planning Act test, I know the committee needs to consider the zoning bylaw. This land is residential, and it permits multiple dwellings, such as a house plus a laneway suite. The bylaw itself permits two-story laneways in general. Another Planning Act consideration is Toronto's official plan. And the plan, of course, supports housing and the development of housing, including the intensification of housing. But it also importantly supports the needs of housing for people with disabilities. And just a quote from section 3.2.1 of the city's official plan, the city intends to encourage new, affordable, and social housing production that meets the needs of people with physical disabilities. And the official plan calls for adequate, affordable, and appropriate housing. In terms of my sister's special needs, there's a letter from her doctor, Dr. Heather Weir, that was filed. And I'll just briefly quote you from Dr. Weir's opinion. Dr. Weir says, the laneway suite is intended for the adult daughter of the Hassel family who has special needs. I have been her psychiatrist for many years. This laneway suite will allow her to have supervised, safe, yet independent living. This will be crucial for her future well-being and care. And my parents at their age, they're in their 70s, they had no desire to get involved into building. But in their 70s, they've been looking for a long-term housing solution for my daughter for many decades. And the idea of a laneway suite would be just ideal. Not only is my sister familiar with the neighborhood, me and my two brothers both have families in the neighborhood, and we live close by, which would be additional support and social activity for her. The laneway suite would therefore be ideal for her future needs. In terms of adequate, affordable, and appropriate housing, the reason this must be 2 stories is that we've included a caregiver bedroom because she will need caregiver support from time to time. We do not like Harry Lay's unsolicited drawings because he puts a big portion of the building. Harry Lay designed a 2-story building, but he put a big portion of that below grade. That's a problem because what would happen at the entrance of the laneway suite is you would be faced with going up or down stairs. That's just not accessible for either my parents as caregiver or for my sister. My mother recently fell down the stairs and broke 5 bones in her foot. My sister has balance issues, and she recently tripped just on the lip to the garage and suffered a lot of bruising from that. So the idea of going below grade is simply not accessible. We're trying to put the laneway suite onto the existing footprint of the garage as much as possible, eliminating the encroachment. In terms of redesign, the original design was higher. This came to the committee November 22nd. The neighbors were concerned about height. The whole laneway suite was redesigned to accommodate the neighbors. The height was significantly reduced and is now at 5.93 meters, which is below the 6.3 meter limit where there's a 7.5 meter setback. But it was necessary to go to 2 stories to accommodate my sister's needs. All levels of government are currently supporting the development of housing, and this laneway suite is not only going to improve the laneway, but it is going to be essential for my sister's future well-being and care. So on behalf of my sister, thank you very much.
Thank you. Mr. Giacometti?
Yes. Hello, can you hear me?
Yes, we can. Do you have any rebuttal?
Yes, I do. First of all, for Miss Lindberg at 41 Regal Road, Miss Lindberg always wished to direct rather than consult with us. She hired 2 architects to prepare unsolicited drawings that are acceptable to her, but no consideration was given for my client's requirements. Her directing even went so far as recommending interior paint colors. 3, the southeast portion of her property is a parking area, which she has not addressed. Please refer to the bird's eye view of the lane. Number 4, her unsolicited shadow study does not indicate the existing shadows versus the proposed shadows, which is misleading because one cannot compare. If you look at my shadow study that I filed with your office, it provides for both the existing and proposed shadows. Okay, so, and there's not much of a difference between one and the other with the existing and the new built form. As for number 37 Regal Road, Mr. Glenn. Mr. Glenn's home is the third house to the east of 43 Regal Road. His home sits approximately 63 feet away from our proposed laneway suite. An existing garage at 39 Regal Road and a tall mature evergreen between 39 and 41 Regal Road will provide more shadowing and do more to block views from his horizontal clear-story window located on his west side yard than our proposed laneway suite will. Number 4, there are several homes east of his property that have deeper rear lots that back onto McLuhan Lane that accommodate a taller 2-story laneway suite with no height variance required. The lane has several, the lane has several rundown garages as well as a large cube van that is parked behind the southern portion of the lane. And dismantling, you know, the rear addition that was put on decades ago isn't going to help anything, you know. It's not going to help just because the lot's not deep. It's not going to help him in terms of his view, which is not blocked. Right, and then number 39 Regal Road, Ms. Grillis, had one letter regarding the fire access, which is a building code issue. And she also has a large mature evergreen tree and a garage that does more foreshadowing and blocking her view than our proposed laneway suite will. And her neighbor's garage at 35 Regal Road also casts a shadow and blocks her view from the west to the west. So I don't think 8-foot ceilings are not, you know, crazy. I mean, they're minimal. We're only going up from grade about 4 inches. So everything is pretty modest. The square footage is modest. We thought that we would keep a garage. And the reason why we want to keep a garage is because parking on the street is at a premium. And I don't want to impact more parking on Regal Road. I'd rather have that contained in the suite, and so we made a minimal garage that Mr. and Mrs. Hassel could get in and out of that is not large. So this is a very modest building. It's not a huge building. It's very modest, and I don't think it's going to. I think it's going to add to the area and provide some kind of provide a pretty interesting build for the lane. It's not going to detract from it. Thank you very much.
All right, thank you. Any questions, panel? Okay, I just wanted to say something. I think I sent something to Carl earlier, I guess last week.
Speak louder, please. I can't hear.
All right, so the neighbors do not take into account the fact that this this laneway suite is being built for a disabled person, and they don't seem to care. I think in the case of disabled people, we've got to put their needs first, and I don't think we should get caught up in all the legalistic stuff that Mr. Glenn was talking about, or worry too much about the neighbors with some slight shadowing in the back of their yard. So I propose that we approve this application. I don't know whether there's any conditions or not, but anyways, Yim?
When I look at the design, actually, this is a very controlled and very carefully done. They're not trying to build even the height is very minimal. And don't forget the distance to the house is actually, they taking it at the closest wall, but the half of the distance is actually larger than 7.5. And with the shadow study, I also observed the shadow study is not going to, because of the location of it, it's not going to impact the neighbors too much. And with the special need, and I think it is a good solution or ideal solution for that family. And I agree with you, Chairman. I will support this because I do not think they're asking too much.
Yeah, Sahir. Sahir.
Chair, I just would like to inform you that I think I may be familiar with one person in opposition, so I'll be abstaining on this particular item.
Okay. Carl?
Thank you, Mr. Chairman. I appreciate the comments of the neighbors. I don't personally think that the issues are as serious as they were presented, and we're not here to judge the design solutions that were created by architects that have not been hired by the applicant. I think that, similar to you, Mr. Chairman, I really do think that we've got to be a bit more compassionate to people with handicaps. And to that extent, I think the idea of a laneway suite is a perfect solution to an adult handicapped person. I think that the applicant in this case has gone to some lengths to try and accommodate the context. I noticed on the facade that faces the existing house, there is a sloped roof. The corner of the building has been cut away to try and reduce some of the impact of the extra height. And I don't think that the extra height in this case is all that egregious. So like you, Mr. Chairman, I am very, very pleased to be supporting, or will be supporting, a proposal that I think is tailor-made for handicapped people in our community.
Nimrod, do you have any comments?
Yeah, I would agree with the comments of my colleagues. I will be supporting this. I do believe that the variances are minor in nature.
I just wanted to make, before I ask for a motion, I just wanted to make a comment about what Mick Hassel said, where he said all four governments support disabled people. Yes, they may, but the bylaws of the City of Toronto do not support disabled people to the extent that they support variances for disabled people in preference to the actual bylaw. And I've had several cases where applications were turned down because the disabled person needed the variances, but the bylaws didn't support those variances. So I'm glad that in this case, it looks like we might be able to get an agreement that the disability takes precedent over the bylaws. But I also agree with Yim and Carl that the applicant in this case has made a great effort to accommodate the neighbors and to put forward a minimal build, but sufficient for their daughter's needs. And I think it's a very good application, and I'd like to call somebody make a motion. Okay, Carl, go ahead.
Thank you, Mr. Chairman. I'd like to move approval of the application subject to forestry condition number 2. As indicated, I think there have been efforts made to reduce negative impacts. I don't feel the negative impacts are that egregious, and I do think that this is a tailor-made solution for a handicapped client, and I'm happy to move a motion of approval.
Kyle, I think we have amended the agenda. We deleted 7, variance 7.
Oh, so forestry 2 isn't needed? Oh yeah, we still need forestry 2, and I'm sorry, it is the amended application.
Okay.
I'll second that. Yeah.
Second the motion. All in
Thank
favor? You have your approval, sir. Thank you very much.
Thank you.
Number 41, 225 Oakwood Avenue. The purpose of this application is to obtain consent to sever the existing property into 2 residential lots. Conveyed, Part 2, Draft R Plan, address to be assigned. Plan 2 has a lot frontage of 6.095.
Good afternoon, Mr. Chair.
Who's that? Pardon?
Good afternoon.
Good afternoon. Who is this?
Good afternoon, Mr. Chair, members. Ida Evangelista on behalf of the owners of 225 Oakwood Avenue.
Yes, we haven't finished the introduction, so if you could just...
My apologies, Mr. Chair. I am here. I just wanted to make sure that everything was working properly.
Yeah. We know you're there.
Okay.
We're getting to you.
No problem. I have lots of patience.
Okay. Part 2 has a lot frontage of 6.095 meters from Oakwood Avenue and an area of 196.1 square meters. A new 3-story semi-detached dwelling will be constructed requiring variances to the zoning bylaws as outlined in application A0810/22 TEY, and retain Part 1, Draft R Plan, address to be assigned. Part 1 has a lot frontage of 6.095 meters from Oakwood Avenue and an area of 196.1 square meters. A new 3-story semi-detached dwelling will be constructed requiring variances to the zoning bylaws as outlined in application A0811/22 TEY. And these applications will be considered jointly. Okay, Ms. Evangelista. Well, wait a minute. I haven't finished yet.
Yep.
We have material from the applicant, and we have our staff report from engineering and urban forestry. Okay, now we can hear from you.
Okay. So what we are proposing, you actually have my submission up now, just to give you a clear picture of what is in the neighborhood, the variances that we are proposing. So, and this is an area, it's quite eclectic. We have bungalows, 2 stories, 3 stories. We have even apartment buildings. It's, on TTC line, Oakwood and St. Clair, and not far from the new LRT. So the variances that we are proposing relate to side yard setback, height, and main wall height. So let me just, if we can just take a look at page 3. I'll just go over. So we are asking for side yard setbacks. The side yard setbacks that we are asking for, and if you can see on the building footprint that I did provide, you'll see that what we're asking for is very consistent with what is in the neighborhood. These are, this is the inner city. What we're proposing here still allows for light, air, and access, safety access. So the main wall height and the overall height. So this area is designated RM, 3-story, 11-meter high. What we're proposing is a flat roof. So it is viewed somewhat, somewhat differently. But if we refer to the side elevation, the front of the house, of the semi-detached homes, steps back considerably. And the height to the top of the front, because if you view it from the street, it would appear as a two-story home. The height from the established grade to the top of the roof at the front of the house is 9.52 meters. At the back, we're also stepping the house at the back. And we've stepped it back. The height at the back of the house is 5.33 meters. So when we have that main wall height and that overall height, it's referred to the portion right in the middle of the home. So the balconies, we do have a balcony, as we know under OBC. We do need a balcony on the third floor. There are other homes in the neighborhood. We have no opposition. Planning is in support of the applications that are before you. We have perfected it to what you have now in front of you. And we are in agreement with the engineering construction services conditions and forestry conditions, of course. And just in closing, Mr. Chair and members, I respectfully submit that the proposed consent and minor variants that are in front of you are desirable and appropriate use of the subject lands. This does form an intensification that is well sought after and very much looked at, and is intensification for this particular area. This is more of the downtown core. It's close to TTC, and I am open to any questions that you may have.
Panel, do you have any questions? Okay. Yes, Carl?
Thank you, Mr. Chairman. I'm just trying to find it on here. Ms. Evangelista, I don't have any difficulty with anything that's before us except the side yard setback on the south side. There is an extremely narrow strip of land because the property on the south, as I'm reading the drawings, is built to the property line. And so what would be left with your proposal is an incredibly narrow way of accessing the rear yard. The same does not seem to be true on the northern parcel, because the building to the north is set back further. So I don't think that the minimal setback is as difficult there. But I really have trouble with the side yard setback on the southerly parcel, because in my view, it just doesn't leave enough room to provide reasonable access to the rear yard. Do you have any comments on that?
Through you, Mr. Chair, the side yard setback on the south portion. So right now we are currently asking for 2 feet, and 2 feet. And as I've had the conversations with engineering, construction services, with transportation, that does permit and allow for enough access to gain access to the backyard. The neighboring home on the side, yes, through you, Mr. Chair, Member Nitfeld, they are up to the lot line. However, we have, and they are not in opposition to what we are proposing. And with the side yard setback that we are proposing is very characteristic in this neighborhood. This is something that is readily seen and known in this particular neighborhood. And most importantly is if access can be allowed and permitted along the side, which it can be. And they do have access on their south portion of their property.
Okay, for the record, I don't agree with you. 2 feet is not adequate. There are so many examples of properties like this where the front yard becomes a horrible mess because people can't adequately get to the backyard. As I said, on the northerly property, I don't think there's much of difficulty, but I have real problems with the side yard setback on this one. So I won't be supporting that part. I have no trouble with the rest of the application.
Through you, Mr. Chair, I don't want to throw the baby out with the bathwater. So if we can increase it, but we also have to take into consideration, you know, how this will affect the remainder of the home. I can increase it to approximately 0.65, and that would give us over 2 feet clearance along the side.
Certainly, that's an improvement.
Mm-hmm.
Okay, can you get one of these garbage bins that the city gives us down that
Yes.
2 feet?
Yes.
You can, okay.
You can't get it down 2 feet. I can clarify that you can't do it to 2 feet because of my own experience, but she's a little over 2 feet in her new proposal, I believe.
Yes, and we do have space in the garage area.
So is the, so you have space for garbage bins in the garage?
In the garage.
At the front?
Yeah, we can put our bins in the garage at the front, yes.
Okay. All right. Any other questions, panel? Yes.
Are we amending the variance to say upon 6.5?
Yes, so.
But it's only on one property, or do you?
Yeah,
Sorry, are you proposing it on both?
No, just on lot 2, on part 2. So on part 2, which is, I believe,
41B.
it is A0810 is part 2. No, just 1 second. We don't want to mess that up. Bear with me for 1 second because it looks like their site plan is.
I have it as lot 2. The one on the south is lot 2. Is that correct?
Yeah, that's what it shows. However, I am looking at the draft R plan, and the draft R plan says otherwise. So I have to go with the draft R plan.
So we have to know whether it's B or C.
So can the staff chime in for 1 second?
Actually, I think it's B. And the reason I do is because of the wording of the condition. It says, 1 second. Variance number 7 says the new dwelling will be located 0.61 meters from the south lot line. And we're talking about, that's the lot line that we were talking about.
Mm-hmm.
So that would be B, right?
That's correct.
If you look at the survey, the part 1 is on the south side.
Mm-hmm. Part 1 is on the south side. That's correct.
It's part 1, Kyle. So it's the C, 41C.
But then the wording of the variance is incorrect.
Yeah.
So if we take a look at file number A0810, that states variance number 7, the new dwelling will be located 0.61 from the south lot line.
Yeah.
So then that would read now 0.65 from the south side lot line.
And only on this one, because the other one talks about the north lot line.
The other, yes. Application 811 talks about the north lot line, variance 7.
So just to add to that, then, is it correct though that the part number, is that correct, or does that part number need to be changed? Because it's either correct here and not correct on the draft R plan, or the draft R plan is correct and the part number is not correct for the variances.
So the draft R plan is correct, but what will happen is when it goes to building permit and it's viewed, that the south lot line has to be 0.65 of a setback. That's how it's viewed, right? So it's not that it's not that the north lot line is 0.65, because now we will be amending it, and when it goes to building permit, it will show that the new dwelling will be located 0.65.
Yes, but liberals, I say that is the part is wrong. That what the southern part is part 1.
And
It's not part 2.
through you, Mr. Chair, on the public hearing notice, 810 shows part 2 and 811 shows part 1. It should be the other way around. So if the deputy secretary is present, is that something that can be re-identified? All the variances are correct. There's no questioning that. It's just they're just the part 1 and the part 2.
Sorry, when the applicant goes for registration for the draft R plan, they can reverse it on the draft R plan.
Yes, I can. Okay, yes, I can do that. Yes, I can do that. Okay.
Yes, I think that's the easiest
That's
way.
easiest. Yeah, okay, I can do that, no problem. Yeah, okay, so then it remains part 2.
But it's variance number 1 that changes?
No. So part 2, variance number 7.
Yeah, right, that's correct.
Well, variance number 1 talks about the front porch and the front 3rd-story deck will be located 0.61 meters from the south lot line.
And that will also read 0.65.
Yeah, okay.
So variance number 1 will read 0.65.
Variance number 7
Variance
as well.
number 7 will read 0.65.
Okay. All right. Did we lose Sahir? It's not there. Okay. Panel.
Sorry, Chair, just had an issue.
Oh, okay. You're here?
Back again.
All right, good. So did you hear this application?
Not quite, so if I may just abstain from it.
Yeah.
I just had to step away for a bit.
Okay. All right. Any further questions, comments, or do we have a motion? Carl?
Unless my colleagues have any further points, Mr. Chairman, I'd like to move approval of the consent application subject to the standard engineering conditions and approval of the amended variance conditions with subject to forestry number 3.
Yes. Okay, do we have a seconder? Yim? All right, all in favor? Okay, unanimous. Zahir is abstaining because he wasn't here for the entire application. Okay, now we go to 42 and 43. 28 and 30 WIDMER. This is also to obtain consent. To obtain consent to sever the property to create 2 new lots and to create various easements, rights of way to facilitate access and servicing. The creation of the new lots provides for as-built adjustments to the property boundary of the residential portion or the mixed-use development currently under construction on the subject lands. The existing residential parcel is previously established pursuant to Committee of Adjustment Decision B0065/17 TEY. And it goes on to deal with many parts. This is a hotel called the Hotel Parcel 1. And then it deals with rights of way over many parts and many parts with easements and rights of way. Then there's a proposed residential parcel with easements, rights of way, etc. So, Madam Deputy Secretary Treasurer, you could copy all this into the, okay. So, with this application, we have material submitted by the applicant. We have email correspondence from Community Planning and Development Planning and Review Area, and a staff report from Engineering. Matthew Schuman.
Good afternoon, Mr. Chair and members of the committee. As you can see from these materials, we're asking that 2 consent applications be considered as companion applications.
Sir, could you just give us your name and your address, please, for the record?
Yes, my name is Matthew Schuman. I'm a solicitor to the applicant. My address is 66 Wellington Street West, Suite 5300 in Toronto.
Okay, so perhaps you could just tell us what this is about.
Yes. So as you mentioned, Mr. Chair, this is about as-built adjustments to a prior consent decision. This application, or these companion applications, I should say, will facilitate and allow the applicants to finish construction of a tower site that is a mixed-use building containing a hotel as well as residential floors, which are anticipated to be registered as part of a plan of condominium. The prior consent was completed early on in the development process to facilitate financing for a separate hotel owner and the residential developer. Now that the building has actually been built, the surveyor was able to go back and make adjustments, and that is shown on the draft reference plan that was submitted, and we've color-coded that draft plan. The large numbers of parts that you see before you are the result of the prior consent and accommodating parts based on earlier architectural drawings. So we have 2 applications because we have 2 existing owners and each with different parts on the reference plan for a total of 4 separate legally described parcels. So what we are asking with this consent is to essentially resever these lots so that we can make adjustments and create the hotel and the residential portions of the building that reflect the actual as-built condition. There is a request that we did discuss with committee staff, and that would be to strike out everywhere they appear in the notices or the decision, and eventually the certificates of official, to strike out parts 193 and 119 from these applications. And when I mention those parts, those are the parts on the draft plan before you. Through our clients' preparation for their condominium application, certain road widening and laneway widening lands were conveyed to the city. That is addressed in the presentation material, so you can see where those parts are, but they are little slivers along the north-south lane and along Adelaide Street. As the chair mentioned, city planning submitted an email where they had no concerns. Transportation Services submitted an email where they had no concerns. Development Engineering, ECF, recommended conditions to this decision that the applicants submit confirmation to the city that the individual owners would provide their contact information to ensure the shared servicing, that there would be a shared servicing agreement in place, and undertakings from the solicitor, their engineer, and their surveyor that appropriate easements were there for those services. Those conditions are also included in the condo application, and the applicant has no concerns with those conditions. So the servicing would be addressed both once you grant this consent, and then could be superseded at the time a condo is registered if any changes were required.
Okay, panel, do you have any questions? Carl?
Thank you, Mr. Chairman. Could you just very briefly explain again, because I'm not sure I understood it. Did you suggest that we are to, through negotiations with staff, you'd like us to eliminate reference to parts 193 and 119? Is that the actual wording that you'd like used?
Through you, Mr. Chair, yes, we'd like the decision to strike out any reference to 3 parts on the reference plan anywhere they appear in the notices, and they are parts number 1, 93, and 119. And the reason for that is those parts were conveyed to the City of Toronto. They are no longer in the applicant's ownership. They're no longer part of these lots.
Thank you very much.
All right, any further questions, comments? Do we have a motion? Yes, Carl.
Mr. Chairman, if no one else has any concerns that they wish to raise, I would like to move approval of the consent application subject to the standard engineering conditions that we have before us and the elimination of references to parts 1, part 93, and part 119.
We have a seconder. Nimrod, all in favor? You have your approval, sir. Thank you.
Thank you all very much. Have a nice evening.
Right, that includes the agenda at 6:40 p.m., 6:49 p.m.